Okay, history what we have discussed. Citizenship. Okay. Have you done the revision of citizenship? Is there any doubts in citizenship chapter? Have you understood all the articles? Okay. Let us study fundamental rights. What is fundamental rights? Why we need that fundamental rights? Why we need that? Is it too important to have the fundamental rights for the people of India? Why so? Okay. Okay. See, these fundamental rights that will help for the human beings, especially the citizens of that country, to have their own rights. Okay. And some of the articles in fundamental rights are absolute in nature. Some of them are just having the limitations for the fundamental rights. And let us see in which part of the Constitution fundamental rights will be dealing with. Part 3 that deals with fundamental rights from Article 12 to 35. Article 1 to 4 that deals with Union and its territory. Article 5 to 11 that deals with citizenship. Article 12 to 35 that deals with fundamental rights. And we have borrowed fundamental rights from which constitution? USA Constitution. Let us study how many fundamental rights are there in an Indian Constitution. Originally, there were 7 fundamental rights in our Constitution. Now, at present, we are having only 6 fundamental rights. Let us see each one. Okay. A right to equality that deals with article from 14 to 18. 14, 15, 16, 17, 18. Then what about 12 and 13? They have not mentioned 12 and 13th article here. Even though the fundamental rights from article 12 to what is article 12 and 13 then? Article 12 that deals with article 12 that deals with definition of state. Definition of state. Article 13 that deals with definition of law. Article 12 that deals with definition of state, and Article 13 that deals with definition of law. The first fundamental right is right to equality that deals with article from 14 to 18. Then comes the right to freedom. That right to freedom is from 19 to 22. Next, right against exploitation from 23 and 24. Only 2 articles in that. Right to freedom of religion, that is from 25 to 28. Cultural and educational rights, 29 and 30. Right to property, article 31. That was been deleted. That was been deleted in a constitution. And next one, right to constitutional remedy. This is one of the important for the citizens of India. If there is any violation of your fundamental rights, if there is any violation of these articles from the state, then automatically the people can be protected under this constitutional remedy is called Article 32. Okay. And Article 31 that has been deleted through which Constitutional Amendment Act? Through 44th Constitutional Amendment Act of 1978. 4 plus 4, 8. 8. Okay. Most of the students, they will choose Article 42. Sorry, Constitutional Amendment Act 42 of 1976. That is wrong. This was been amended and it was been deleted under this 44th Constitutional Amendment Act 1978. Okay. Right now we are having how many fundamental rights? 6 fundamental rights. Right against right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. These are the present fundamental rights in the Constitution. This was been deleted. Okay, let us see each one of them. Okay, from Article 12, 13 to Article 32. First one, that is Article 12 of the Constitution. Article 12 of the Constitution. As I told you, Article 12 that deals with what? A definition of a state. In our Constitution, the definition of a state doesn't mean the Rajya. Here, the definition of a state means all this. Okay, let us see what are those. First, according to the Constitution, the definition state includes all these. First one, government and Parliament of India. That is executive, legislative organs of the Union government. Here, the definition of a state that includes what? Parliament of India. That is central government. The first central government, that comes the state government. Legislature of state means state government. And the third one, that is local authorities. Which are those? Municipalities, panchayat, district boards, improvement trusts. These comes under the word state. Okay. Parliament, that is central government, state government, local governments, and municipalities. And there will be certain district boards. Have you heard this district boards? Have you seen that? Have you seen the district boards? Example, like see here, district boards, it might be in the sense like it may be related to the agriculture boards, okay, and it might be related to the departments, government departments, and also banks which are comes under the government. Okay, that all comes here. Okay, district boards like DCCB bank, that is district cooperative society banks. See, these kind, that all which are under the government, that are running under the government, that is owned by the government, that all comes here. Next one, all other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SIAL, GAYAL, Life Insurance Corporation, Oil and Natural Gas Corporation, Steel Authority of India Limited, Gas Authority of India Limited. Okay, these are running under the government ownership. That's why these all comes under the definition of a state. Okay, and if there is any violation of fundamental rights from these bodies, you can approach Supreme Court or a High Court. Okay, if there is any fundamental, if any of your rights have been violated from the definition of a state, then you can approach the Supreme Court or High Court. Okay, see here, the state has been defined in a wider sense, so it is so as to include all its agencies. These are all the agencies of the definition of a state. Okay. If there is any violation from these agencies, that can be challenged where? In a courts. Okay. And that is what the definition of a state gives you. Definition of a state includes what? Parliament, state legislature or state government, local bodies like panchayat and municipalities, district boards. Then comes public sector undertakings, PSU. These are the PSUs, public sector undertakings. Public sector undertakings means these are the companies or factories that will be running under the government of India or government of state. Is there any doubts? You can just write down keywords also. These are the public sector undertakings. Finish? Next one. Article 13. Here, the Article 13 that deals with what? Definition of law. What is law? Okay. Let us see what is meant by law. Article 13 declares that all laws that is inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressively provides the doctrine of judicial review. Okay. Let us see what is Article 13. Here, the term law is defined in Article 13 of the Constitution. What is that law? These are the different types of laws. One is a permanent law. That permanent law will be created by whom? Parliament or else state government. You have seen already the union list, state list. That is what? Those are the permanent laws. Permanent laws will be enacted by the either the central government or state government, parliament or state legislature. Next comes the temporary laws. ಸುಗ್ರೀವಾಜ್ಞೆ ಅಂತ ಕರಿತೀವಿ ಕನ್ನಡದಲ್ಲಿ. Okay. These temporary laws are the ordinances. These are ordinances means ಸುಗ್ರೀವಾಜ್ಞೆ. And this ordinance is only issued by the president or else a state governors. It can be again revoked back. The laws can be again revoked back. ರದ್ದುಪಡಿಸಬಹುದು. Okay. And when this temporary laws will be created, do you have an idea? Okay. Yes, when there is no session in a parliament, in times of like emergency, not the national emergency, but in times of very quickly, one of the law should be enacted. In that time, the president is having the right, the governor of the state is having the right to create these temporary laws for certain specific period. It might be months, it might be years also. Again, once the session starts, when Rajya Sabha and Lok Sabha, again it is present in the parliament, then it can be revoked back. These temporary laws can be stopped. Next one, statutory instructions. The instructions like whatever the order that is been given by the government of India or government of state, orders issue ಮಾಡಿರ್ತದೆ ನೋಡಿ ಅದು. Next, bylaws. What is bylaw? These are like again the temporary kind of law for a certain specific period of time. Okay, by the executives and the state legislatures. This temporary law is made by president or state government. But idu yaru antandre executives or legislatures. Next, rules, regulations and notifications that is released by the government of India or government of state. All the notifications, whatever it releases, it might be exam notification or any notifications, all that comes under the definition of law. Okay, and if there is any law is violating the fundamental rights, then it will be declared as null and void by the Supreme Court. Only the judicial review can be given by whom? Supreme Court. Okay, if any of the law is violating the fundamental rights of the people, it will give the judicial review, and if the law is unconstitutional, then it will be declared as null or void. Okay, this is what they have given now. If the law, if any of their fundamental rights are unconstitutional, you can approach the Supreme Court through which article? Article 32. You can approach the High Court with the which article? Article 226. If your fundamental rights from Article 14 to 30, Article 14 to 30, if it gets violated, then you can approach the Supreme Court with the help of this article, and for High Court with the help of 226th article. You can write down. Finish. Next article, Article 14. Article 14. What is Article 14? What is Article 14? Equal before law and equal protection of law. See here. In Article 14, we are having two laws. One is equal before law and equal protection of law. Our constitutional makers thought that to add only the equality before law. But some of the other constitutional makers have decided why not to add this one also. Let us see what is the difference between two. When we see this one, it looks very similar. Equality before law, equal protection of law. It looks similar. But that is not the same case here. See, the equality before law that is being borrowed from a British constitution, or else it is originated from the British. This concept is originated from the British. And this concept is originated from the USA, or USA have been adopted this one. Our Indian constitutional makers adopted both of them. In different circumstances, they can use this one. Okay. First, B ಇದೆ, ಇದು B. Okay. And this one P ಇದೆ. Okay. And then obviously we'll get to know. One the British ಮತ್ತೆ USA ಮಧ್ಯ ಅಷ್ಟೇ we have borrowed this one. Okay. And what is equality before law? Equality before law, what is meant by that? No one is above the law. No one is above the constitution. Then okay. Then yes. All the citizens. Okay. Whether you are rich or poor, whether you are a male or a female, whether you are a politician or a common citizen, it doesn't matter. For a same offense, same punishment. Okay. And this is what we'll use, the equality before law. Okay. It will not discriminate between the rich and poor. It will not discriminate between the politician and common people. It will not discriminate between the genders also. Okay. That is what called as equality before law. Before law, everybody are equal. Okay. Here, equal protection of law, there comes the discrimination. Okay. Here, likes will be treated as likes. Here, the likes will be treated as likes. Likes will be treated as likes means same offense, same punishment. Whether you are rich or poor, it doesn't matter. Whether you are VIP or politician, it doesn't matter. The same for same offense, same punishment. Here, likes will be treated as likes. Likes are not treated as likes. Let us see. Let us give me the example. Think that, for example, okay, for criminal offenses, if we take the criminal offenses, here, if any of the person murder, if any of the person murders, okay, think that his age is around about 25. If his age is around about 25, he murders one person. And think there is another person, 30 or 35. Okay, same offense, that is a murder. For both of them, the punishment will be the same. Okay, think this is a politician, he has murdered someone. Okay, this is a common citizen, he has murdered someone. The same punishment will be given for the same offense. It will not discriminate between you are rich or poor, you are VIP or you are normal person. Okay, but when it comes to the equality, equal protection of law, it varies. There the concern arises. There the discrimination arises. Okay, let me give one example for you. A person whose age is 30, he has shot with a gun for someone and he murdered. a person. Okay, and the same, the baby, the 6-year-old baby, okay, without knowing what is the gun, okay, think that his father would have been a police officer. When he has kept his gun on the table in a home, okay, and he didn't lock the gun, and the baby will think it is a toy and it will start to play. And unfortunately, during that time, without knowing that it's a like weapon used to kill, what the baby will do? Eventually, when it starts to play with that, it will trigger and it will just shoot someone. Okay, think that in that time, some of the person have been died. Okay, the 6-year-old baby, it also committed a crime. Then here there was an intentional, but here there was no intentional. The circumstances will be observed by the court, the judges. Then there will be a no punishment for the baby. The same offense, but here the age gap is there. There is a difference in the age gap. The situation is different. Crime is same, but the situation is different. Based on a situation, they will give the punishment. Understood? Here, who will be protected? For whom the protection will be given? The protection will be given for the children who commits crime. The protection will be given for the woman. The protection will be given for the weaker section, physically challenged person. Okay, based on circumstances, the lesser punishment will be given. Understood? Punishment irtada, but it is less compared to the normal punishment what they get. Understood? Do we wanted this kind of law or not in India? Based on a situation, can they decrease the punishment or not? Do we want this in our India? Yes, we want both also. Okay, that's why constitutional makers have added both the laws in Article 14. Understood? Here, the protection is for whom? Protection is for children. Protection is for, think that the woman is after her job at 9 o'clock or 10 o'clock, if she is going to the home, while going towards the home, some of the attackers will attack her and they try to rape her. During that time, what she will do? Self-protection, self-defense. In that self-defense, think that she might beat the person without intentionally, that person may die. Okay, during that time, the court will hear the situation, what has been happened. Based on the circumstances, the punishment will be lesser or even no punishment at all. Understood? See, ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತಿದೆ, ಜುವೆನೈಲ್ ಜಸ್ಟಿಸ್ ಸಿಸ್ಟಮ್ ಅಂತ ಇದೆ. ದೇರ್ ಈಸ್ ಜುವೆನೈಲ್ ಜಸ್ಟಿಸ್, ಬಾಲ ಅಪರಾಧಿಗಳು ಅಂತ ಕರಿತೀವಿ. See, the age 17, 18. If that minor child, if he commits a crime at the age of 17 or 18, still he didn't attain the major, okay, that age 18 innu agilla. Before the age of 18, like it is 16.5 based on, see, the let's see is like 16.5. Let me give an example. If his age is 16.5 years or 17 years or 17.5 years, okay, so on, but less than 18 age, during that time he will be a juvenile. Okay, he is a minor still. But think that if this child have committed a crime like rape or acid attack, okay, those are heinous crimes, okay, or murder. In that case, there will be a counselor. Okay, psychologically they will study this child's brain, whether it is developed or not. Even though his age is less than 18, but their mentality will be matured. If their mentality is like a matured person, if he thinks like more than 18 kind of a person, then they will declare this person as a major at all. Understood? Even though physically his age is lesser than 18, but mentally he has grown up. And due to that, he has committed a crime with the help of the courage what he's got, with the help of extremism, whatever he's thinking. Okay? And ದೊಡ್ಡವ್ರ ತರ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಇವನ್ ದೋ ಲೆಸರ್ ಏಜ್ ಅಲ್ಲಿ ಇದ್ರು ಕೂಡ ದೊಡ್ಡವ್ರ ತರ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಅಂದ್ರೆ he will be just given in the ಏನ್ ಕೊಡ್ತಾರೆ ಅಂತಂದ್ರೆ in that document, in that report, he will be given as a major itself. And based on that, the court again it will do the trial. There will be hearings and trial. If the judge ಗೆ ಏನಾದ್ರೂ ಇವರು ಮೇಜರ್ ತರ ಅಂತ ಅನ್ಸಿದ್ರೆ ಮಾತ್ರ judge the punishment will be given. For whom? For this person. Equal punishment for whom the major accused person ಮಾಡಿರ್ತಾರಲ್ವಾ, same punishment will be given. But this is the rarest of the rare case ನಲ್ಲಿ ಹೋಗ್ತದೆ. 18 ಸಿ ಏನಾಗ್ತದೆ ಅಂತಂದ್ರೆ, unfortunately, see, that is what the situation circumstances ಎಲ್ಲಾನು ಅಲ್ಲಿ ನೋಡ್ತಾರೆ in the hearing. While there is a trial, that is what they will see, the circumstances, in what circumstances he committed a crime, whether it was intentionally or unintentionally. That is what it is the duty of the lawyers to prove both the opponents. Understood? Okay, ಈ ಕಡೆದವ್ರ ಲಾಯರು ಇವ್ನು ತಪ್ಪು ಮಾಡಿದಾನೆ ಅಂತ ಹೇಳಿ ಪ್ರೂಫ್ ಮಾಡ್ತಾರೆ, ಈ ಕಡೆದವ್ರು ಮಾಡಿಲ್ಲ ಇಂಟೆನ್ಷನಲಿ ಮಾಡಿ ಇವರು ಪ್ರೂವ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. Okay, and that is why the solid proof should be submitted for the court, then they can decide. Okay, judge can't decide and give the punishment without the counseling report. The doctors will be there. Firstly, he will be sent and visited in the psychological department. Then there will be a doctors. They will just counsel him. Once the report given by the counselors, the psychological counselors, then based on that, the judge will again do the trial, the hearings. Based on that, he will give the punishment. The judge will give the punishment. Okay. In Hubli, just a 8th standard boy have killed the 10th standard boy. Okay, while they were playing, ಗಲಾಟೆ ಆಯ್ತು ಅಂತ ಹೇಳಿ ಚಾಕುವಿಂದ ಹೋಗಿ ಚುಚ್ಚಿಬಿಟ್ಟ. Okay, see, that is what they will study here. Okay, and once our mentality, maturity, ಏನಕ್ಕೆ ಈ ತರ ಮಾಡ್ತಾ ಇದ್ರು, what was the reason behind that, everything they will study. Okay, only maximum ನೋಡಿ 17 ಏಜ್ ಇಂದ or 16.5 ಏಜ್ ಇಂದ 18 ಏಜ್ ವರೆಗೂ ಇರೋರು ಮಾತ್ರ ಇದು ಈ ತರ ಪನಿಷ್ಮೆಂಟ್. The punishment like a major accused person, whatever he gets that. But if he is below the 16 age, he will be considered as juvenile itself. Lesser punishment will be there. Okay, maximum might be only 3 years for them. No capital punishment will be given for these juveniles. Understood? ದೊಡ್ಡೋರ್ ತಪ್ಪು ಮಾಡಿದ್ರೆ capital punishment will be there, death punishment will be there. But for them, there is no kind of death punishment. Maximum might be only 3 years of punishment. Heinous crimes ಮಾಡಿದ್ರು ಕೂಡ only 3 years or 7 years maximum. That's it. Okay. Is there any doubt in this? Due to social media, these kinds of crimes will happen. The murdering, blackmailing, okay, and also rape. Okay. And parents also, it is the duty of the parents to observe what the child is doing. Okay, and mobile na kodsi sumne ಕೂರೋದಲ್ಲ parents ಕೆಲಸ. They should cross check what my child is doing in a phone. Okay, what he is doing on social media. Everything they should cross check. Okay, ಅಲ್ಲಿ right to privacy ಅಂತ ಬರೋದಿಲ್ಲ for the child. More than age of 18 ಇದ್ದವ್ರು ಮಾತ್ರ they can use the social medias. Okay, they can watch the other contents. If not, no. ಈ ತರ ಇರ್ತದೆ ಅದು. And restrictions are there for these 18 below, less than 18 age children. Okay, they should not watch See, on YouTube also, on social media also anta bandaga restriction will be there. Have you seen that option? Less than age of 18 plus idor matra they can accept this. Okay, these are the content. Okay, on YouTube also. Okay. And the movies also are there. U plus, UA, A plus, sorry, A anta heli ತರ ಸೆನ್ಸರ್ ಇದನ್ನ ಕೊಡ್ತಿರ್ತಾರೆ ನೋಡಿ. Okay, based on that the child can watch that movie. As I told you, the concepts of this one. Okay, and see here, this is a negative concept, this is a positive concept. Why negative? Here, based on situation, they will not decrease the punishment here. Everybody are equal, same punishment. But here, based on a situation, that accused person can be protected, or else he can be getting lighter punishment as well. This is a positive concept. Understood? This is derived from which origin? British. This is from USA. This is negative, this is positive. Understood? But in India, based on circumstances, if the justice accepts whether this is unintentionally, this murder have been happened, or rape, not rape, murder have been happened, or else accident have been happened, based on that judge might give a lighter punishment also. Okay? Especially for women. Okay, ಪ್ರಾಕ್ಟಿಕಾಲಿಟಿ ಎಲ್ಲಿ ಹೇಳ್ಬೇಕಂದ್ರೆ ವುಮನ್ಗೆ ಸ್ವಲ್ಪ ಇದೆ ಕನ್ಸರ್ನ್, ಲೈಕ್ ಸಿಚುವೇಶನ್ ಆ ತರ, ಬಿಕಾಸ್ ಶಿ ಬಿಲಾಂಗ್ಸ್ ಟು ದ ವೀಕರ್ ಸೆಕ್ಷನ್. Even though she is physically strong, but as being a woman, she is having that fundamental rights. She can protect herself. She will get the lighter form of punishment. But intentionally ittu antandre the same punishment for her as the man gets. But if it is unintentionally, she will get the lighter punishment. And also, this ಈ ಅಪರಾಧಿ ಇರ್ತಾರೆ ನೋಡಿ, ಹೆಣ್ಮಕ್ಳು ಅಪರಾಧಿಗಳು. Okay, if she is having the child, and during that time if she has committed any crime, if the judgment have come that she is accused and she has already committed a crime, she is guilty. Okay, if she is guilty, if the child is less than 5 age, ಆ ಮಗುನ ಅಲ್ಲೇ ಪ್ರಿಸನ್ ನಲ್ಲಿ ಬಿಡ್ತಾರೆ ಅವಳ ಜೊತೆನೆ, ಬಿಕಾಸ್ ಟಿಲ್ ದ ಏಜ್ ಆಫ್ 5 ವರೆಗೂ ಆ ಮಗು ಅವಳ ಜೊತೆನೆ ಇರ್ಬೇಕು. Okay, if she is mentally not stable, mentally retarded, then that will be handed over for the father, ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ. But first priority will be given only for the woman if she is mentally stable. Mentally stable ಇದ್ಲು ಅಂತಂದ್ರೆ, ಪ್ರಿಸನ್ ಅಲ್ಲಿ ಇದ್ದಾಳೆ ಅಂತಂದ್ರೆ ಕೂಡ ಚೈಲ್ಡ್ ನ ಅಲ್ಲೇ ತಾಯಿ ಹತ್ರನೇ ಬಿಡ್ತಾರೆ. ಶಿ ಇಸ್ ಮೆಂಟಲಿ ರಿಟಾರ್ಡೆಡ್, ತುಂಬಾ ಸೈಕಾಲಜಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ ಅವಳಿಗೆ ಅಂತಂದ್ರೆ ಅದನ್ನ ಫ್ಯಾಮಿಲಿ ಒಪ್ಪಿಸ್ತಾರೆ ಆ ಮಗುನ. Next one is Article 15. And also this Article 14, that is having an exceptional. Okay, it is having an exceptional for whom? This is not applicable for whom in India? The president and state governor. If there is any criminal proceedings against the president of India or against the state governor, no criminal proceedings, no investigation can be against the president or governor. Criminal case like murder or else rape, okay, ಆ ತರ ಆಕ್ಸಿಡೆಂಟ್ ಈ ತರ ಮಾಡಿದ್ರು ಕೂಡ ಅವ್ರ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಗಳು ಆಗಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಸ್ ಆಗಲ್ಲ. ಓಕೆ, ಇಫ್ ದರ್ ಇಸ್ ಎನಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಲೈಕ್ ಡಿಸ್ಪ್ಯೂಟ್ ಲ್ಯಾಂಡ್, ಆ ಕೇಸಸ್ ಅವ್ರ ಮೇಲೆ ಇತ್ತು ಅಂತಂದ್ರೆ, ದೆನ್ prior 2 months before the notice should be issued for the president or the state governor, then they can get investigated. Understood? ಈ ತರ privileges ಇದೆ. But what about if the president of India commits a crime, criminal, activity or criminal case. What if he does the crime? What if he or she does the crime then? See, during that time, while she's in office, none of them can go and investigate against her or against him if he is a president or state governor. Firstly, if there is any solid evidence of that the president or state governor have committed crime, suddenly in Lok Sabha or Rajya Sabha, there will be a proposal, impeachment proposal that takes place. In Lok Sabha, if that MP or else minister initiates that removal procedure, the impeachment procedure, 100 members should sign. If the speaker accepts, then the special majority in Lok Sabha. Then it will be passed in Rajya Sabha. The same way, special majority there. Okay, and then the president can be impeached. Once the president can be impeached, during that time, the criminal proceedings can take place. Till while the president is in office, no criminal proceedings. First our designation the ಕೆಳಗಿಳಿಸಬೇಕು, then there can be a criminal proceedings. Understood? ಯಾಕಂದ್ರೆ ಸ್ಥಾನ ಹಂಗಿದೆ. In order to protect that designation, that's why there will be no criminal proceedings while the president will be in office. Understood? Okay. Practicality ಒಳಗೆ ಅದೇ ಮಾಡೋದು. Okay. Firstly, or impeach ಮಾಡಾದ್ಮೇಲೆ criminal proceedings as it is. Is there any doubt? Doubts. Exceptions to equality. Okay, exceptions to equality. That is, president and governor of state. President and governor of state enjoys the immunities like Article 361. Under Article 361, president, state governors enjoys the immunities like no criminal proceedings while they are in office. And the civil proceedings can be only investigated before 2 months period of notice should be given. Okay, itara. No, it is not for MPs. For criminal proceedings, while he is in office, he can be investigated. Only president and state governors are having the exception, not even the PM, not even the CM. CM, PM, ಅವ್ರ ಸ್ಥಾನದಲ್ಲಿ ಇದ್ಲಾಗ್ರೂ ಕೂಡ ಅವ್ರ ಮೇಲೆ criminal proceedings ಆಗ್ಬಹುದು, investigation ಮಾಡಬಹುದು. But the immunity is given for only whom? President and state governor. Even PM, even the ministers, MP, MLAs, MLC, CM, ಎಲ್ಲರೂ ಕೂಡ, for them, if they have committed crime, if there is any investigation order to take place, automatically they can take the proceedings against them. Okay, and also no action will be taken against the news channels, the radio, newspaper, if there is a publishment of true reports. Understood? ಏನಾದರೂ ಒಂದು ಟ್ರೂ ರಿಪೋರ್ಟ್ ಅನ್ನ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಈ ನ್ಯೂಸ್ ಚಾನೆಲ್ ಅವರು, ನ್ಯೂಸ್ ಪೇಪರ್, ರೇಡಿಯೋಸ್, no proceedings, no criminal proceeding, no civil proceedings against media. But the coverage, that subject, that matter should be true. ಊಹಾಪೋಹಗಳು ಏನಾದ್ರು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರೆ ಡಿಫಾಮೇಶನ್ ಕೇಸು. ನೀನ್ ಟ್ರೂ ವರದಿನ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದೀಯ ಅಂತಂದ್ರೆ ಯು ಆರ್ ಜಸ್ಟ್ ಪ್ರೊಟೆಕ್ಟೆಡ್ ಅಂಡರ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಓಕೆ, and also foreign diplomats also having the immunity power regarding criminal and civil proceedings. Think that the USA diplomat, US embassy is working in Delhi. Okay, and this foreign diplomat, if he commits a crime, murder or rape, there is no punishment for him in India. Understood? like IFS officer, how we are having as a diplomat, the same way the other foreign countries, they are also having their own embassy. These ambassadors, they will be working in India as well. If they commit a crime in India, there is no kind of a punishment for these people. The immunity will be given. But ಏನು ಅಂತಂದ್ರೆ once they commit a crime, suddenly at that moment the Ministry of Home Affairs and of External Affairs Minister, all that people will send him for his own country. ಇಲ್ಲ ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ ಇಂಡಿಯಾದಲ್ಲೇ ಹಿಂಗ್ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರೆ then he will be getting arrested. Okay, this kind of incident have already happened in India. See, he belongs to the foreign country. We can't give him a punishment here in India. Okay, but that country can give him a punishment, whatever the offense he has done in India.
But in case of citizenship of India, then India can.
Yes, India can give him a punishment. Since he is a foreign citizen and foreign diplomat, he is working in our government of India. He is representing his country in India as being a diplomat, as being a government servant of that country in India. We can't give him a punishment for a civil as well as criminal proceedings. He is having that immunity. And suddenly we will send him back for his own country. Okay, and he will be not working in India anymore. If he stays again here after 24 hours also by working here in India, then automatically the police can arrest him. And then they will send directly for that country.
How come this Arab states have sent the 9 officers?
Recently, ಏನಾಯ್ತು?
Arab countries, 9 persons you have mentioned as one of the armed.
See, the law is there like that. But in our Constitution of India, constitutional makers given a privileges for these diplomats, foreign diplomats. ನಮ್ಮಲ್ಲೂ ಆ ಥರ ಏನಾದ್ರು ಕಾನೂನು ಇತ್ತು ಅಂದ್ರೆ they would have also got the punishment. But in order to have a good relationship with that country, see, if for the diplomat gets a punishment in India, what it shows, the India is very crime, like they don't even have a humanity and inhuman ಆಗಿ ನಡ್ಕೊಳ್ತಾ ಇದೆ ಅಂತೇಳಿ they will publish that kind of report in their own country and the relationship will get deteriorating. Relationship ಹಾಳಾಗ್ತಾ ಬರ್ತದೆ ಒಂದು ಕ್ರೈಮ್ ಇಂದ. ಅದಕ್ಕೆ ಏನು ಅಂತಂದ್ರೆ ಆ ಒಂದು ರಿಲೇಶನ್ಶಿಪ್, in order to maintain a good relationship with them, that's why we'll not give a punishment for the foreign diplomat in India. Understood? Okay. But most of the time, the Arab countries, they also released our officers. Most of the time they have released. ಏನಾಗ್ತಿತ್ತು ಅಂದ್ರೆ, see, while they are transporting through ship or else through navy, some of our fishermen, they will reach the Arab countries due to the heavy waves. A high wave ಜಾಸ್ತಿ ಆದಾಗ ಕಂಟ್ರೋಲ್ ಸಿಗೋದಿಲ್ಲ ಅದು. ಬೋಟ್ಸ್ಗಳು, ನಾಟ್ ಅ ಶಿಪ್, ಬೋಟ್ಸ್ಗಳು ಏನಾಗ್ತಿದ್ರು, ಸಡನ್ಲಿ ದೇ ವಿಲ್ ರೀಚ್ ದಿ ಅದರ್ ನೇಷನ್ ಅಂಡ್ ದೆನ್ ದೇ ವಿಲ್ ಬಿ prisoned, and then they will get arrested and they will be prisoned, and they will interrogate him whether you are a spy or what, whether you are threatening, are you a terrorist or what. They will, everything they will cross check, and if they feel that they are like innocent people, then they will release them. If they don't feel innocent, still they will be prisoned at all. And then the PM of India and concerned ministers will write a letter for them and they will just take the apologize, they will apologize, and then ಅವ್ರು ಏನಾದ್ರು ಒಪ್ಪಿದ್ರೆ ಮಾತ್ರ they will release. If not, no. Death punishment will also be there sometimes. Have you understood this one, Article 14? Okay, there are exceptions also. State for a president, for state governor, and for a media, and also for foreign diplomat. Okay. Next, Article 15. Article 15. Let us see what is Article 15. What is Article 15? Prohibition of discrimination on certain grounds. What are the certain grounds? Yes, religion, race, caste, sex, place of birth. Okay, these are the 5 grounds. Based on that, we should not discriminate. See here. Article 15 provides what? The state should not discriminate. Means the governments should not discriminate. The central government, state government should not discriminate. Based on only, what are those? Religion, race, caste, sex, place of birth. Okay. And, but it can discriminate on other grounds. ಈ ಗ್ರೌಂಡ್ಸ್ ಮೇಲೆ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಬಟ್ ಬೇಸ್ಡ್ ಆನ್ ಅದರ್ ಗ್ರೌಂಡ್ಸ್ ದ ಸ್ಟೇಟ್ಸ್ ಕ್ಯಾನ್ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್. ಲೆಟ್ ಮೀ ಟೆಲ್ ದಟ್ ಆಲ್ಸೋ ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್ಸ್ ಇಟ್ ಕ್ಯಾನ್ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ and it cannot discriminate. Okay. Firstly, the word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. Here, Article 15 that says no citizen shall be subjected to disability liability restrictions on these grounds. Firstly, access to shops, public restaurants, hotels, place of public entertainment. Access to shops, okay, stores. Based on these grounds, he can't be discriminated. Think I am going for the public shop. If he discriminates me based on my gender, that is sex, if I am female, if they are restricting me, then it is violation of my fundamental rights. Next, public restaurant. In public restaurant, they can't discriminate me based on my religion. Only Hindus can't be allowed there. Even the Muslims create a movie. It is not only meant for the Hindu religion there. That is what they have given. From these grounds, they should not get discriminated. Next one, the use of wells, public wells, ಬಾವಿಗಳು ಇರ್ತಿತ್ತು ಹಳೆ ಕಾಲದಲ್ಲಿ. Next, tanks, bathing ghats, roads, place of public resort maintained wholly or partly by the state's funds. That too should be of general public use. Okay, that all, see, in ancient days, the upper caste people used to have their own separate well. The lower caste people used to have own separate well in village areas. ಅವ್ರ ಬಾವಿಯಲ್ಲಿ ಇವ್ರ ನೀರ್ ತಗೊಳಂಗಿಲ್ಲ, ಇವ್ರ ಬಾವಿಲಿ ಅವ್ರ ನೀರ್ ಟಚ್ ಮಾಡೋಂಗಿಲ್ಲ, ಈ ತರ ಇತ್ತು. Next, tanks, public ghats also. Even roads were only meant for the upper caste people to travel, ನಡ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ. Okay, and while they are going on the road, okay, ಹೋಗ್ತಾ ಇರುವಾಗ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ ಪೀಪಲ್ ಅವರು ಏನಾದ್ರು ಹೋಗ್ತಾ ಇದಾರೆ ಇಲ್ಲಿ ಕಚ್ಚಾ ರೋಡ್ ಅಲ್ಲಿ ಅಂದ್ರೂ ಕೂಡ ಅವ್ರದ್ದು ಶಾಡೋ ಇಟ್ ಶುಡ್ ನಾಟ್ ಫಾಲ್ ಆನ್ ದಿಸ್ ಪರ್ಸನ್. ಈ ತರ ದೇ ಯೂಸ್ ಟು ಡಿಸ್ಕ್ರಿಮಿನೇಟ್. Okay, that was case in village. Till now in some of the villages it is going on. Okay, ಅದು ಇನ್ನೂ ಹೊರಗಡೆ ಬರ್ತಾ ಇಲ್ಲ ಅದರಿಂದ. And also place of public resort wholly or maintained by the state government. Here all that you will be having the access. Based on these grounds, they can't discriminate. But based on the other grounds, they can discriminate here. What grounds? Other grounds on the see, this one, point B there, this point B, it is for both private people and state government. Even the private, even the other public, ಒಬ್ರಿಗೊಬ್ರು ಏನಾದ್ರು ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೂ ಕೂಡ ಪನಿಷ್ಮೆಂಟ್ ಸಿಗ್ತದೆ. ಬಟ್ ಇದೆ ನೋಡಿ, ಫಸ್ಟ್ ಒನ್, ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ ದ ಸ್ಟೇಟ್. ದ ಸ್ಟೇಟ್ ಕಾಂಟ್ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್. That is what they have given here. The farmer while the former provision prohibits discrimination only by the state. ಸ್ಟೇಟ್ಗಳ ಶಾಪ್ಸ್ಗಳು ಇರ್ತದೆ ನೋಡಿ, ಪಬ್ಲಿಕ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಸಿಸ್ಟಮ್ ಅಂತ ತಗೊಳ್ಳಿ, PDS ರೇಷನ್ ಶಾಪ್ಸ್, ಅಂಡ್ ಆಲ್ಸೋ ಪಬ್ಲಿಕ್ ರೆಸ್ಟೋರೆಂಟ್ಸ್. ಇವಾಗ ಇಂದಿರಾ ಗಾಂಧಿ ಕ್ಯಾಂಟೀನ್ ಅಂತ ಇತ್ತು, ಅಲ್ಲಿ ದೇ ಕ್ಯಾನ್ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಬೇಸ್ಡ್ ಆನ್ ದೀಸ್ ಗ್ರೌಂಡ್ಸ್. The same way, hotels, if that is working under a state government, okay, they can't restrict based on this religion. Sorry, based on this they can't discriminate. Is there any doubt here? No doubts. But based on other grounds, they can discriminate. How? If any of the person have got the infection of COVID, during that time they can discriminate. Understood? If there is any leprosy, kushroga ittu andre, they can discriminate. If there is any contagious disease that person have got, adu innobರಿಗೆ ಹರಡ್ತದೆ ಅಂತಂದ್ರೆ, during that time they can restrict that person of coming for these areas. Understood? But HIV ಇದೆ ಅಂತ ಹೇಳಿ ಇದಕ್ಕೆ ಬಿಡಬಹುದಾ? Yes, they can go, because it's not a contagious disease, transmittable ಅಲ್ಲ ಅದು, only it's a sexually transmitted disease. ಹೌದಾ? ಅದು ಏನು ಅಂತಂದ್ರೆ, ಇಟ್ಸ್ ನಾಟ್ ಲೈಕ್ ಅ ಕಂಟೇಜಿಯಸ್ ಡಿಸೀಸ್, ಲೈಕ್ ಅ ವಾಟರ್ ಬಾರ್ನ್, ಏರ್ ಬಾರ್ನ್ ಅಲ್ಲ ಅದು ಡಿಸೀಸ್. ದಟ್ಸ್ ವೈ even those people, HIV, the people also can access these one. ಅವ್ರಿಗೆ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಮಾಡೋ ಆಗಿಲ್ಲ. ಅಂಡರ್ಸ್ಟುಡ್? ಡ್ಯೂರಿಂಗ್ ಕೋವಿಡ್ ಆ ಟೈಮ್ ನಲ್ಲಿ ನಾನು ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನನಗಂತ ಹೇಳಿ ಇವ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅಂಡರ್ಸ್ಟುಡ್? ದೇರ್ ಆರ್ ಸರ್ಟನ್ ಗ್ರೌಂಡ್ಸ್, ಡ್ಯೂರಿಂಗ್ that time they can restrict. Understood? In this article 15, they started to give the reservations. Discrimination ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತದೆ, but in that only they started to give the reservation for economically weaker section, for socially backward section, especially for SC and ST. For scheduled caste, scheduled tribe, they started to give the reservation for whoever they were socially backward and economically backward, educationally backward. Okay. And then comes the EWS, that is economically weaker section. Okay. Those income whose, okay, if the income is less than 8 lakh, they will be under the economic weaker section. Whoever are general merit, like upper caste people, even though they are economically weaker, okay, the criteria is it should be less than 8 lakh per annum. Okay, and also along with that, ಇನ್ನೊಂದಿಷ್ಟು ಕೆಲವೊಂದಿಷ್ಟು ಇದೆ, 5 acres of agriculture land ಮೇಲೆ ಇರಬಾರ್ದು. These whoever wanted to avail this economic weaker section reservation, they should not have more than 5 acres of agriculture land, and also 1000 square feet residential flat ಮೇಲೆ ಇರಬಾರ್ದು. Okay, 1000 square feet ಮನೆ 30-40 ಇರಬಾರ್ದು. 20-30 it's okay. 2 into 20 into 30, 600 square feet. 20-30, 30-40, 1200, 1200, 3 4s are 12, 1200 ಆಗ್ತದೆ. Understood? Okay, residential flat should not be more than 1000 square feet. Residential plot of 100 square yards for notified municipalities. Okay. ಈ ತರ ಏನು ಅಂದ್ರೆ it should not move it more than that if you wanted to avail the EWS. This economically weaker section, that reservation was being given through which Constitutional Amendment Act? 103rd. Okay, 103. Just write down 103. The 103rd Constitutional Amendment Act 2019. Economically weaker section, the reservation is given for them for educational sector, for employment opportunity sector, through the 103 Constitutional Amendment Act in 2019. Understood? Next. Next is Article 16. Equality of opportunity in public employment. In terms of government opportunity, government job, this is related to the government job. Public opportunity means the government opportunities. Here, no citizen can be discriminated based on religion, race, caste, sex, descent, vamsha, other mela, and place of birth, residence. None of the citizen of India can be discriminated for the government job, for the educational sector on these grounds. ಅಲ್ಲಿ ಯಾವ್ದಿತ್ತು? In previously it was religion, race, caste, sex, place of birth. This one and this one not mentioned there. Here they have been mentioned. Okay, and let us see. The best example, have you watched the movie Vamshi? That was the one. Based on his descent, based on the father of his father, what he has done. He was criminal, I think so. Based on that, they rejected him in an interview. That is what the state can't do. Based on a religion, race, caste, sex, descent, ನಿಮ್ಮ ವಂಶ ಏನೇ ಗೂಂಡ ಇರಲಿ ಏನೇ ಇರಲಿ ಮರ್ಡರ್ ಇರಲಿ ಬಟ್ if you don't have any crime active, the crime cases against you, then you are eligible for the government jobs. ನಿನ್ ತಂದೆ ತಾಯಿ ಏನ್ ಮಾಡಿದ್ರು, ನಿಮ್ಮ ಇಡೀ ವಂಶನ ಏನ್ ಮಾಡಿದ್ರು, it doesn't matter. Only what you have done, that matters. Okay. And the residence means a temporary staying in the area. Okay, based on that ground they can't just discriminate. Okay, and see here, the Karnataka people can't get discrimination. They should not get discrimination for writing the UPSC exam. Okay, that is what here, place of birth. If I am born in Karnataka, I am eligible of writing the UPSC exam. I am eligible for writing the other state service exam, but I should write the qualifying paper of that religion language as well. Understood? The other non-Kannadigas, non-Karnataka people can write the exam, but they should firstly qualify the paper called as Kannada, compulsory Kannada. Understood? That is what they have given here. They can't restrict based on a place of birth, based on a residency. Next. Okay. For this, the government of India appointed a commission called as Mandal Commission. Okay. It was headed by BP Mandal. BP Mandal was a MP during that time. Okay. In 1979, Morarji Desai government appointed BP Mandal, and that name was Mandal Commission. Here, the work of the Mandal Commission is to just give the report regarding the backward class people. Already they were knowing the scheduled caste, scheduled tribe people, the population of scheduled tribe and scheduled caste people. Firstly, scheduled caste to scheduled tribe people in Article 15 only they know what is the population of them, how much we should give the reservation for them. But Morarji Desai government thought of giving the reservation for the backward class people also, ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗೂ ಕೂಡ. Okay, and this BP Mandal this BP Mandal Commission have given some of the recommendations also, and along with that they have given a report based on the socially and educationally backward class. Whoever are economically, educationally and socially backward, they have given the report. How many percentage of the backward class people are there in India? Okay, let us see that how many people are there. In India, round about 3,743 caste, those were socially and economically backward. Thousands of castes are there. In that backward caste are these one. Socially and educationally, these are the backward classes. And along with that, round about population ಎಷ್ಟಿತ್ತು ಅಂತಂದ್ರೆ, yes, the population was 52%. Out of 100, 52% of the population belongs to backward class. Out of this 52%, they have given a reservation of 27%. Population is still there, 52%, but reservation given is how much? 27. See here. The recommended reservation was 27% for government jobs for backward class people. Understood? And also along with that, see here. For scheduled caste, for scheduled tribe. For scheduled caste, it was 15% of reservation out of 100. 100% ನಲ್ಲಿ ವೇಕೆನ್ಸಿ ಇತ್ತು ಅಂದ್ರೆ 15 ಸೀಟ್ಸ್ ಯಾರಿಗೆ ರಿಸರ್ವ್? SC, scheduled caste. For ST it is 7.5%. For OBC, other backward class, it is 27%. The total it will be 49.5%. It should not exceed more than 50. That is what the Supreme Court has said. Whatever the reservation gives by the government of India, you can give, but the reservation should not exceed more than 50%. That's why it is 49.5%. Understood? Write down that. Including economic weaker section, it will happen how much? 59.5%. Including economic weaker section. Finish? See here, the Supreme Court said that it has given instruction, the judgment that it should not exceed more than 50%. But Tamil Nadu government gave the reservation up to 69% in their state. It has crossed more than 50. Now, again the Supreme Court asked the question, it questioned the Tamil Nadu government. Why you have given the reservation of 69%? Why you have exceeded more than 50%? It was been questioned. Then the Tamil Nadu government given a report that in their own respective state, majority of the people belongs to the scheduled caste, scheduled tribe. That's why they have increased the reservation. Then based on that, Supreme Court has agreed for giving the reservation of 69%. It doesn't declare null and void. Okay, based on the population in that area, they can increase the reservation. Understood? In some of the other states, they have exceeded more than 50, and also they have given the report based on a population of that section. They can increase the reservation also. If there are more number of scheduled caste in that state, they can increase the reservation. General merit, general caste ನವರು ಕಡಿಮೆ ಇದ್ದಾರೆ ಅಂತಂದ್ರೆ ಕಡಿಮೆ ರಿಸರ್ವೇಶನ್ ಕೊಡ್ತಾರೆ. Based on population, they can increase or decrease the reservation. Next is Article 17. Abolition of untouchability, अस्पृश्यते. Abolition of untouchability. See, this untouchability was been following in India for thousands of years, since from ancient India itself. Okay, and the definition of untouchability is nowhere mentioned in the Constitution, but the definition is given by the what? Mysore High Court. Mysore High Court illa, then how they have given this judgment? Sorry. Yes. In the time of 1955, our Karnataka was being called as what? Mysore. That's why Mysore High Court. Okay. And what they have given, the definition given by the Mysore High Court is untouchability has not been defined either in the Constitution or an Act. However, Mysore High Court held that subject matter of Article 17 is not untouchability in its literal grammatical sense, but practice as it has developed historically in the country. Historically, whatever they have been practicing, that is called as untouchability. That definition was being given by Mysore High Court. ಅನಾದಿ ಕಾಲದಿಂದಲೂ ಏನೋ ಒಂದು ಫಾಲೋ ಮಾಡ್ತಾ ಬಂದಿದ್ದಾರೆ ಅಲ್ವಾ, ದಟ್ ಈಸ್ ವಾಟ್ ಕಾಲ್ಡ್ ಆಸ್ untouchability. Okay. And see, in 1976, the Untouchability Offence Act of 1955 was amended and ಒಂದು ಹೊಸ ಹೆಸರು ಕೊಟ್ಟರದಕ್ಕೆ, ಏನು, ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಸಿವಿಲ್ ರೈಟ್ಸ್ ಆಕ್ಟ್ ಅಂತ ಹೇಳಿ. Now we are having Protection of Civil Rights Act of 1955. None of the citizen of India can condemn that person belongs to scheduled caste, scheduled tribe. ನೀನ್ SC ಇದೆಯಾ, ನೀನ್ ST ಇದೆಯಾ ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಪಂಗಡಗಳು ಇರ್ತದೆ, ಅದನ್ನ ತಗೊಂಡು ಬೈಯೋ ಆಗಿಲ್ಲ. That is a non-bailable case. Okay, bail ಸಿಗೋದೇ ಕಷ್ಟ. And recently, just 2 years back, okay, and one of the video, ಉಪೇಂದ್ರ ಅವರು ಒಂದು ವರ್ಡ್ ನ ಯೂಸ್ ಮಾಡಿದ್ರು ಒಂದು caste ಗೆ. It was been so viral, and then he got the bail directly from the High Court itself. Okay, see, that is what the controversy that happens. Okay, we should be very cautious while dealing with this one. Okay, ಕೆಲವೊಬ್ರು politicians ಆಗಿರ್ಲಿ, okay, ತಿಳುವಳಿಕೆ ಇಲ್ದವರಾಗಿರ್ಲಿ, they will condemn based on a caste. That should not happen. In order to protect the scheduled caste, scheduled tribe, that's why the untouchability, abolition of untouchability, that law have been added in a constitution. ಹಳೆ ಕಾಲದಲ್ಲಿ ತುಂಬಾ ಇತ್ತು. Okay, the upper caste people used to condemn the lower caste people, the scheduled tribe, scheduled caste people, based on their caste itself. But it was too inhuman. And nowadays, it was been misutilizing. ಈ ಒಂದು ಅವ್ರಿಗೆ ಪವರ್ ಏನಾಗ್ತಾ ಇದೆ, ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ, ಇದೇ scheduled caste, scheduled tribe people. Okay, if there is any fight was going on, think there is any fight is going on in public, okay, between the upper caste and ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ ಆರ್ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಪೀಪಲ್. ಫಸ್ಟ್ ಕೇಸ್ ಏನ್ ಹಾಕ್ಬಿಡೋದು, ನನಗೆ ಬೈದ, ನನ್ನ ಕಾಸ್ಟ್ ಬಗ್ಗೆ ಬೈದ. Okay, this will be misused. This protection will be misused by the scheduled caste, scheduled tribe people sometimes. But case should be registered. FIR ಆಗ್ಲೇಬೇಕದು. Then it is the duty of the other person, the upper caste person, to prove his innocence. ನಾನು ತಪ್ಪು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇವನು ಪ್ರೂವ್ ಮಾಡಬೇಕು. ಐದರ್ ಇಟ್ ಶುಡ್ ಬಿ ಅ ಪ್ರೂಫ್, ಲೈಕ್ ಆಡಿಯೋ ಆದ್ರೂ ಇರಬೇಕು, ವಿಡಿಯೋ ಆದ್ರೂ ಇರಬೇಕು, ಆರ್ ಎಲ್ಸ್ ಅದರ್ ಪರ್ಸನ್ ಶುಡ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ವೈಲ್ ದೇವರ್ ಜಸ್ಟ್ ಫೈಟಿಂಗ್ ಈಚ್ ಅದರ್. ಹೌದಾ, ಒಬ್ರಿಗೊಬ್ರೇ ಇದ್ದಾಗ ಬೈದು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ವಿತೌಟ್ ಪ್ರೂಫ್ ಕೇಸ್ ನಡೆಯೋದಿಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ದೇರ್ ಶುಡ್ ಬಿ ಸಾಲಿಡ್ ಎವಿಡೆನ್ಸ್ ಆಲ್ಸೋ. ಓಕೆ, the Supreme Court held that the right under Article 17 is available against private individuals. ಅಂದ್ರೆ ನಮ್ಮ ಪಬ್ಲಿಕ್ನವರು ಅವ್ರವ್ರೇ ಏನಾದ್ರು ಹೀಯಾಳ್ಸೋದು ತೆಗಳೋದು ಮಾಡಿದ್ರು ಅಂದ್ರು ಅವ್ರ ಮೇಲೆ ಬಿತ್ತು ಕೇಸು. Okay, it is not only against the state government. It is not only against the state here. Okay, even the private individual also will get the punishment. Non-bailable offense adu. See, untouchability in the sense that ಅಸ್ಪರ್ಶತೆನೂ ಕೂಡ ಒಂದು ಟಚಿಂಗ್ ಆಗಿರ್ಲಿ, ಒಂದು ಬಯೋದನು ಆಗಿರ್ಲಿ, contains both. That untouchability, that word contains both. Okay, and restricting the person to enter into the temple, that is also untouchability. ಹೌದಾ? And see that all these scheduled caste, scheduled tribe people, all these will be protected under the fundamental rights of this one. ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್ ಇದು, ಯಾಕಂದ್ರೆ ಡಾಕ್ಟರ್ ಬಿ ಆರ್ ಅಂಬೇಡ್ಕರ್, okay, is the one who has given some kinds of laws for protecting these Dalits in the country. This is also one of them that is included. Next one, Article 18. Okay. Abolition of titles. Abolition of titles. It is having 4 provisions. Okay. It prohibits the state from conferring any title, that is, except military and academic distinction on anybody, whether a citizen or foreigner. See, our government of India, our government of state cannot issue the titles either for the citizen of India or else for the foreigner. Okay, let me give one title for you. In UK, they will award with a title called as sir or madam. That kind of title should not be given by government of India. Sir M. Vishweshwaraya. That title was been given as an award. ಹೌದಾ? ಈ ತರ those kind of titles should not be conferred by whom? State government or even the central government for our citizen or else for even the foreigner. But it can give only what? Military titles like lieutenant, captain, general. ಈ ತರ ಕೊಡ್ಬೋದು. And academic title means doctor. Okay, if you got the doctorate in philosophy, okay, or else if you are having the degree of MBBS, if you have pursued the PG, that is masters in surgery or in medicine, okay, ಅಲ್ಲಿ ಏನ್ ಕೊಡ್ತಾರೆ, ಡಾಕ್ಟರೇಟ್ ಅಂತ ಕೊಡ್ತಾರೆ. That can be used. Understood? Next, it prohibits a citizen of India from accepting any title from any foreign state. ಈ ತರ ಟೈಟಲ್ಸ್ ನ ಇಸ್ಕೊಳ್ಳೋಗಿಲ್ಲ, madam ಅಥವಾ ಸರ್ ಅಂತ ಹೇಳಿ. ಇಟ್ ವಿಲ್ ಪ್ರೊಹಿಬಿಟ್. ಇನ್ ಕೇಸ್ ಇಸ್ಕೊಳ್ಳೇಬೇಕು ಅಂತಂದ್ರೆ they should take the permission from President of India. Okay. Yes. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of President. Even the foreigner who is working in India, he can't accept the titles that is given by his own country also without our President's consent, because he is working in India. That's why. ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಏನಕ್ಕೆ ಅವರು ಇದನ್ನ ತಗೊಳ್ಳೋದು ಟೈಟಲ್ಸ್? See, that's why it will restrict. It should take the permission. Next, no citizen, ನಮ್ಮವರೇ ಆಗಿರ್ಲಿ ಫಾರಿನರ್ ಆಗಿರ್ಲಿ, no citizen or a foreigner holding any office of profit or trust under the state is to accept a emolument or office from or under any foreign state without the consent of President. With the help of President only, they can entitle the titles. Okay. See, from the above, it is clear that the hereditary titles can't be used. Hereditary titles like bantala dasara ivaga ಮಹಾರಾಜ, ಯದುವೀರ್ ಒಡೆಯರ್ ಅಂತ ಹೇಳಿ, ಈ ಮಹಾರಾಜ ಅನ್ನೋ ವರ್ಡ್ ನ ಯದುವೀರ್ ಒಡೆಯರ್ ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿಕ್ ಬರೋದಿಲ್ಲ. Understood? It has been abolished. These kind of hereditary titles have been abolished in India because all the rajas who were there, ಅವರೆಲ್ಲ ಕ್ಲಾನ್ಸ್ಗಳು, ಅವರೆಲ್ಲ ವಂಶದವರು, they are equal to the citizen of India now. That is why they have abolished the hereditary titles. ಯದುವೀರ್ ಒಡೆಯರ್ ಅಂತ ಹೇಳಿ only that name can be utilized officially. ಮಹಾರಾಜ ಅಂತ ನಾವು ನೀವು ಕರಿತೀವಿ, the public can say that, but officially they can't use in parliament as being an MP. He is just Yaduvir Wadayar there. Understood? See, Maharaja, Raj Bahadur, Rai Saheba, Diwan Bahadur, these titles can't be used as a prefix and suffix for their names. They are just equal with the citizen of India. That's why. Okay. See, that is what they have given here. The colonial states are banned, Article 18, as these are against the principle of equal status of all. Ellargu equal status ide anta heli. That's why they have banned this kind of hereditary titles. Understood? Prefix and suffix are used ಮಾಡ್ಕೊಳ್ಳಾಗಿಲ್ಲ. But the people can just call them as Maharaja, Maharani ಅಂತ ಹೇಳಿ. But ಅವ್ರು ಅಫಿಷಿಯಲ್ ಆಗಿ ಇಟ್ಕೊಳ್ಳೋಕೆ ಬರೋದಿಲ್ಲ. Then, in 1996, the Supreme Court upheld the constitutional validity of national awards. See, the national awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. Highest civilian award yaudu? Bharat Ratna. Second highest, third, that is fourth. Okay. Padma awards are of three types: Padma Vibhushan, Padma Bhushan, Padma Shri. Okay. What here tells that it ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Only hereditary titles will be banned, but these are called as awards. Okay, idella awards, the titles alla. Okay, and therefore they are not violative of Article 18, as the theory of equality does not mandate that merit should not be recognized. These are of merit basis. ಏನೋ ಒಂದು ಸಾಧನೆ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿರ್ತಾರೆ ಇದನ್ನ. Okay, ಇದನ್ನ ಏನ್ ಮಾಡಬಹುದು? They can use, but not hereditary titles. Okay. However, it states that ಏನ್ ಹೇಳ್ತದೆ ಅಂದ್ರೆ ಇದನ್ನು ಕೂಡ ಪ್ರಿಫಿಕ್ಸ್ ಅಂಡ್ ಸಫಿಕ್ಸ್ ಆಗಿ ಯೂಸ್ ಮಾಡ್ಕೊಳಕ್ ಬರಲ್ಲ ನಿಮ್ಮ ನೇಮ್ ಮುಂದೆ. That is what they will tell you. However, it also ruled that they should not be used as suffixes or prefix to the names of the awardees. Awardees ಗಳಿದ್ದಾರೆ ಅಲ್ವಾ, ಅವ್ರ ಕೆಳಗಡೆ ಭಾರತ್ ರತ್ನ ಅಂತ ಹಾಕೊಳ್ಳಿಕ್ ಬರಲ್ಲ. Understood? Okay. And ಪದ್ಮಶ್ರೀ, ಪದ್ಮ ವಿಭೂಷಣ್ ಅಂತ ಈ ತರ ಪ್ರಿಫಿಕ್ಸ್ ಅಂಡ್ ಸಫಿಕ್ಸ್ ಆಗಿ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಬರೋದೇ ಇಲ್ಲ. And otherwise, ಏನಾದ್ರೂ ಯೂಸ್ ಮಾಡಿದ್ರೆ ಆ ತರ ಮತ್ತೆ ಹಿಂಪಡ್ಕೊಳ್ತಾರೆ ಅವಾರ್ಡ್ಸ್ಗಳನ್ನ, ಮೆಡಲ್ನ. ಅಂಡರ್ಸ್ಟುಡ್? ಇನ್ ದೇರ್ ನೇಮ್ ಪ್ಲೇಟ್ or in any officially, the suffix and prefix agi they should not use these awards with their names, or else they will be forfeit the awards. Marali tagoltare. These national awards were instituted in 1954. First Bharat Ratna award was been won by whom? First Bharat Ratna. R in the start ಆಗ್ತದೆ ಹೆಸರು. Just check. You know that person. ಇಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ. First Bharat Ratna award was won by whom? Yes, Rajgopalachari and Radhakrishna. Understood? R in the start ಆಗುತ್ತೆ. See here, the maximum awards won for the Bharat Ratna is how many? How many of the people can win a Bharat Ratna in that year? It is actually 3 in number. But ಹೋದ ವರ್ಷ 5 ಮೆಂಬರ್ಸ್ ಕೊಟ್ರು ಭಾರತ್ ರತ್ನ. 2 or 3 for posthumous ನಿಧನ ಹೊಂದಿದವರಿಗೆ. See, these awards can be given for a person who is living and also a person who is posthumous. Okay, ಅವ್ರಿಗೂ ನೀಡ್ತಾರೆ. And only 3 members ಅಷ್ಟೇ ನೀಡ್ತಾರೆ ಅದನ್ನ ಅವಾರ್ಡ್ಸ್ ನ. But the BJP government awarded for a 5 person. Okay, posthumous, including the posthumous people. One time ಏನಾಗಿತ್ತು, this was been discontinued. Bharat Ratna was been discontinued in Morarji Desai government, because during that time what was there? National emergency was there. Okay, again it was been reviewed by the Indira Gandhi ji. Is there any doubt in this? Okay, hereditary titles are abolished and they can't use these kinds of awardees names in prefix and suffix of the names. No. If you just get the doctorate, that is academic one. That can be utilized without the permission of the president. There is no, we should not take the consent. There is no necessity of taking the consent of the president of India. Only military and academic titles ಗಳನ್ನ ನೀವು ಇಲ್ಲೇ ಫಾರಿನ್ ಅಲ್ಲಿ ಇಸ್ಕೊಳ್ಬಹುದು. But not these kinds of titles called as sir, madam, ಈ ತರ titles ತಗೊಳ್ಳಿಕ್ಕೆ ಮತ್ತೆ you should take the permission. Understood? Just write down this article 19, very important. Okay, let's take a break and we can continue article 19. Next is Article 90. Okay. How many articles are there in Article 19? How many rights are there in Article 19? 6 rights are there in Article 19. Let us see those. First one, right to freedom of speech and expression. Right to freedom of speech and expression. See here. Article 19, Clause 1, Subclause A. This is Article 19. Here it is a Article 19, Clause 1, Subclause A. Article 19, 1, Clause, Subclause B. This is 19, Clause 1, Subclause C. 19, Clause 1, Subclause D. 19, Clause 1, Subclause E. 19, Clause 1, Subclause G. E ಆದ್ಮೇಲೆ G. Why so? Yes, right to property. Right to property, that is 19 clause 1 subclause F was been deleted with the help of 44th Constitutional Amendment Act 1978. That's why I have written G directly. Understood? Okay. See, what is the first right? Right to freedom of speech and expression. This right to freedom of speech and expression, it explicitly, it is not absolute right. It is not a guaranteed right. It is having certain limitations. When it will be having the limitation, on what grounds it will be having limitation, let us study that also. Firstly, the speech and expression can be given by any person. Okay, his views, his thoughts can be expressed in the form of communication, in the form of gesture, in the form of writing, in the form of painting, in the form of typing, printing. That all can be called under the word expression. Expression andre bari ಬಾಯಿ ಮಾತಿಂದಲ್ಲ. All these are included in the speech and expression. But it is having certain limitation. Since the Constitution of India has given the freedom for expression, freedom for speech, doesn't mean that whatever we wanted to, whatever the thoughts and views, that can't be publicizedly defamed. Okay, for that there is a limitations. Okay, and this speech and expression, it includes the following: freedom of press. Freedom of press also comes here because it is also a speech. The journalism, that is a speech, that is the views that they give. Freedom of press, freedom of commercial advertisement, and right against tapping of telephonic conversations. Okay, that also. Okay, gotaita, right against tapping of telephonic conversation. Think that two persons are speaking to each other, and the third person, if he taps that phone, okay, then it is a violation of this article. He should not. See, there are some of softwares nowadays. Well, two persons are having the communication. This person, with the help of that software, what he will do is he will tap that phone. He will hear whatever the conversation will be going on. Okay, that is what it will violate this article. It will violate the privacy also, right to privacy, and this also. Next, right to telecast on electronic media. That is, government has no monopoly on electronic media. But these press media should only publish the true report on electronic media. They are having that right, but they don't have the right for publishing this gossip kinds of matters. ಊಹಾಪೋಹಗಳು ಇಲ್ಲ. Okay. And also right to know the government activities, whatever the government is doing, the work. The public is having the right to know what the government is doing, and also and press media is also having the right to know what these politicians are doing. Not in terms of personal matter, but only in terms of professional way. ಸಿಎಂ ಗಳಿಗೆ ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಬೀಯಿಂಗ್ ಎ ಸಿಎಂ ಅಂತ ಕ್ವಶನ್ ಮಾಡುವಂತ ಅಧಿಕಾರ ಇದೆ ಪ್ರೆಸ್ ಮೀಡಿಯಾ, ಬಟ್ ನಾಟ್ ಇನ್ ಹಿಸ್ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್. ಅಂಡರ್ಸ್ಟುಡ್? ನೆಕ್ಸ್ಟ್, right against imposition of pre-censorship on the newspaper censorship. Okay, that can only, the censorship can be only imposed only in certain cases, but not in every cases. Okay, and the politicians can't restrict them, the governments can't restrict of having these kinds of censorships. Okay, and next one, a right to strike. It comes under freedom of speech and expression only. Is the public, if the public wanted some of the laws which wanted in support for the public, then they will go on a strike. Whatever the law that is opposing the public's views, or if the law is very stringent, very rigid, then what these people will do? They will go on a strike. They are having the right to go on a strike in a mass gathering, but they should take the permission of government, the police department. Understood? And on what grounds these can be restricted? The freedom of speech can be restricted based on, there are 8 grounds for that. One is contempt of court. Contempt of court means the public, the people should not defame the judge, and also they should follow up that judgment, whatever that is given by the government, this courts. Understood? Whatever the judgment they give, they can't oppose that. Okay, they should follow that judgment. Next one, defamation. Okay, ಮರ್ಯಾದೆ ಹಾಳು ಮಾಡೋದು. Okay, that should not be publicizedly, they should not defame any person. And next one, morality and public order should be maintained. If the public order is not maintained, this person who is violating the speech and expression, they will be just get arrested. Okay, and also on the grounds of sovereignty and integrity of India. Okay, on social media, the people can view their expression, can view their thoughts, beliefs, but it should not deteriorate, or it should not lead to the chaos. Okay, communal rights, communal violence. It should not hurt the sentiments of people. It should not, integrity of nation na ಹಾಳು ಮಾಡಬಾರ್ದು. Okay, and also decency should be there, morality should be there. Okay, and also security of the state, security of the nation. Security of the nation na breach ಮಾಡಬಾರದು, ನಾನು ಏನೇ ಒಂದು ಹೇಳಿಕೆ ಕೊಡೋದು. Okay, along with that, friendly relation with foreign states. Whichever the nations they are good with they are friendly with the India, we should not defame that country. Otherwise, it will lead to the damage between the relationship between India and the other nation. We can condemn Pakistan because it's an enemy country, but we can't condemn the other foreign nation which are very good friend of us. Okay, have you understood? Next one, the second one will be right to assemble peaceably and without arms. People can assemble in the public, but without the arms. Okay, And it is related to the strikes also. Okay, peacefully they can go for a strike, they can do the strike, but not with the help of weapons. And it should not lead to the violence. That strike should not lead to the violence. Is there any doubt? And you will see here section 144, curfew, here itself. Okay, if there is any violence, if there is any threat, and if the people are using the arms and weapons, then the curfew can be imposed. Section 144 of CRPC can be imposed. That is curfew. ಅಸೆಂಬಲ್ ಆಗ್ಲಿಕ್ಕೆ ಅವಾಗ ರೈಟ್ಸ್ ಇಲ್ಲ ನಿಮ್ಗೆ. ಐ ಆಮ್ ಹ್ಯಾವಿಂಗ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಅಂತ ಹೇಳಿ ಹೋಗ್ಲಿಕ್ಕೆ. ಅಂಡರ್ಸ್ಟುಡ್? Is there any doubt? See, peacefully they can assemble in a public land. Okay. See, if there is any kind of a function in public, they are organizing that, but it should be in peaceful way. They can assemble. Thousands of people can gather. That is what called as right to assemble. ಪ್ರವಚನ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ನೋಡಿ. That can, they are having that right. That is a fundamental right. But a pravachanದಲ್ಲಿ should be without arms. Okay, there should not be any violence. Next, a right to form associations or unions or cooperative societies. What is that? Right to form association, ಸಂಘಟನೆಗಳು, ಸಂಘಗಳು ಕಟ್ಬಹುದು. Okay, they can form the associations. Association means political parties. It includes political parties, it includes the companies, firms, private partnership as well. Okay, all these having the rights to form this kind of associations. And also unions. Unions ಅಂತ ಇರ್ತದೆ ನೋಡಿ. ಆಟೋ ಚಾಲಕರ ಸಂಘ, ಕಾರ್ಮಿಕರ ಸಂಘ, okay, labor union, okay, and ರೈತರ ಸಂಘಗಳು. That all the people will be having the rights to form this one. Is there any doubt? No doubts. Next. Next comes right to move freely throughout the territory of India. As I told you, every citizen of India is having the right to move from one place to other place, but they can't move for the restricted areas. Okay, there are some of the restricted areas where the tribal people will be living. Okay, these urban people, they can't go for the tribal areas, the restricted areas, because the tribal people's culture will be different, the language will be different, their customs are different. We should not go and we should not threat them. They feel like we are aliens for them. They even try to kill the urban people. Have you seen that? Okay, in some of the islands and in some of the areas, especially in India also, there is a restriction because they feel that we are enemies for them. There are some of the tribal people where they are very friendly in nature for us, for the urban people. Some of the tribal people are so backward, still they are living in the ancient era. ಇಷ್ಟು ಫಾರ್ವರ್ಡ್ ಆಗಿದೆ, AI ಬಂದಿದೆ, ಎಲ್ಲ ಬಂದಿದೆ. Still they are not even, they don't even know the clothing, they don't even know the other food items as well. Still they are eating the raw food items. Have you seen that? Okay, those kinds of people, we should not disturb those kind of people. Let them live and let us also live. Wherever there are scheduled tribe, the tribal areas which are restricted, okay, there is a restrictions. Especially their culture is different, language is different, customs are different, and manner of the scheduled tribe, they live totally a different way. Okay. Is there any doubt? And once you see this, any citizen of India can move from one state to another state. ಯಾವ್ದು ಜಿಲ್ಲೆಗೆ ಬೇಕಾದ್ರೂ ರಾಜ್ಯಕ್ಕೆ ಬೇಕಾದ್ರೂ ಹೋಗ್ಬೋದು. But only restriction is in the tribal areas, certain tribal areas. But prostitutes are restricted for their movement in public places. Okay? Prostitutes are restricted in public places, especially in railways, bus stand. Think there is a railway station or bus stand here. In that 200-meter radius, they should not be there. They can be. Andre ಏನು ಅಂತಂದ್ರೆ they should profession ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅವ್ರಿಗೆ ಅಲ್ಲಿ. But you are seeing in Majestic, there's a lot of there are many people in public places. Still there are. See, according to fundamental rights, these people are restricted in public places. 200-meter radius ನಲ್ಲಿ ಅವ್ರು ಇರಲೇಬಾರ್ದು. ಓಕೆ, ಅವ್ರು ಅದನ್ನ ಏನು ಅಂದ್ರೆ ಆ ಪ್ರೊಫೆಷನ್ ಅಲ್ಲಿ ಅವರು ನಿರ್ವಹಿಸಕ್ ಆಗೋದಿಲ್ಲ. But practicality is different, and even though the police will be there, they will not take any action because of various reasons. But according to the law, they are restricted in the public place. If willingly she agrees, if she does that in a private area, she is having the right to choose her profession. But in public, she can't force a man or any of the person can't force, the prostitute can't force for any person there in public. That is what you will be studying. Understood? Next, right to reside. A right to reside and settle in any part of the territory of India. The citizen of India can reside throughout anywhere in India. Being in Karnataka, Kannadiga, I can stay in any of the place in India. Okay, but there are some of the restrictions, that is to the tribal areas, and I should take the permission in order to just reach out for the tribal areas as well. Okay, the government in the tribal people ನೋಡ್ಬೇಕು ಅಂದ್ರೆ I should take the permission. Okay, in some of the tribal areas. Okay, that is what the restriction is there. But I can reside somewhere, anywhere throughout the India. And in Bangalore, you are seeing that the outsiders of Karnataka, those people are residing in Karnataka, in Bangalore. They are having their right, that is fundamental right. None of the Kannadiga can question that right. Frequently, this issue will be going on once in 3 months, one is in 4 months. One is ಭಾಷೆ ಬಂತಂದ್ರೆ ಇನ್ನೊಂದು for them, Kannadigas will condemn those person. Why are you staying here? Okay, see, that issue will be there. Okay, but according to Constitution, every citizen of India are having the right to stay in any of the place. Okay, they can stay in Bangalore also. We can also stay in outside of the Karnataka as well. Okay, it is their fundamental right. Nobody can question that. Okay, even the central government, state governments can't question that. Understood? And even when it comes to language, they can speak their own language, but they can't defame the Kannada language. But we can't impose Kannada compulsory for them. According to Constitution, we should follow that. Okay, emotions are totally different than what the law is. Okay, ನೆಲ ಜಲ ಭಾಷೆ ಅಂತ ಬಂತು ಅಂದ್ರೆ ಅದು ಬರ್ತದೆ. Okay, see, that is why the future civil servants should know all these things. Okay, and they should balance between they should balance these kind of issues between Kannadigas and non-Kannadigas. Okay, according to Constitution only you should work being a civil servant. ಓಕೆ, ಇಬ್ರು ಕಡೆಗಳಲ್ಲೂ ನೀವು ಬಗೆಹರಿಸಬೇಕಾಗ್ತದೆ ಆ ಇಶ್ಯೂಸ್ಗಳನ್ನ ನಾಳೆ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ. And you can't, being a Kannadiga, you can't say that I am Kannadiga, you should also compulsorily speak Kannada. Yeah. Okay. Only with the help of emotions, only by being a friendly relationship with those persons, we can teach them the Kannada if they are interested. But we can't impose and we can't force the persons to speak in Kannada or any of the regional language. If you go for Tamil Nadu or Maharashtra, there you can speak the Kannada or else any of the language which were you know, but they can't impose or put the restriction that you should know a Marathi or else Tamil. Understood? Next, right to practice any profession, to carry on any occupation, trade or business. Okay, right to practice any profession or carry on any occupation, trade or business. Any citizen of India can choose any profession. Okay. In ancient India, based on a profession only, they have brought the caste system. But any citizen of India can't get the restriction for choosing the different profession. Okay. ಕುಂಬಾರರು ಬರೀ ಮಡಿಕೆ ಮಾಡಕ್ಕೆ ಅಷ್ಟೇ ಸೀಮಿತ ಅಂತ ಹೇಳಿ we can't restrict them. They can also become IAS officer. They can also become politician. Okay. ಕುರುಬರು ಅಂತ ಹೇಳಿ ಬರೀ ಕುರಿ ಕಾಯೋದು ಅಷ್ಟೇ ಕೆಲಸ ಅಲ್ಲ. They can become officer. They can become politician. They can choose any of the legal professions. Okay. Based on a caste, the profession is not required there. Okay. They can choose any of the profession irrespective of their caste. It doesn't matter. And also the trade and business as well. All these should be in legal way. Is there any doubt? No doubts. The next is Article 20. See, write down, see, it doesn't mean that choosing a profession, profession andre legal, not a illegal one. Human trafficking, drug smuggling, prostitution, forcing prostitution. That is illegal. ಸ್ವಯಂ ಪ್ರೇರಿತವಾಗಿ ಪ್ರಾಸ್ಟಿಟ್ಯೂಷನ್ ಪ್ರೊಫೆಷನ್ ಚೂಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ದಟ್ ಈಸ್ ಲೀಗಲ್ ಇನ್ ಇಂಡಿಯಾ. ಓಕೆ, ಒಂದ್ ಹೆಣ್ಮಗಳು ಅದನ್ನ ಆ ಪ್ರೊಫೆಷನ್ ನ ಫೋರ್ಸ್ಫುಲ್ ಅಲ್ದೇನೆ ಇಫ್ ಶಿ ಚೂಸಸ್ ದಟ್ ಪ್ರೊಫೆಷನ್ ಶಿ ಕ್ಯಾನ್, ಶಿ ಇಸ್ ಹ್ಯಾವಿಂಗ್ ದಟ್ ಲೀಗಲಿಟಿ. ಬಟ್ if someone forces her to choose that profession, that is illegal. And also drugs, explosives, manufacturing of explosives, that all are illegal. Okay. Only legal profession, legal trading, legal business can be chosen by any citizen of India. See, transgenders anta bandre others anta kottidare. They are not mentioned the transgender anta heli option. Others anta ide. That have been added recently. Okay. Here caste, here gender or caste alli barodilla. Gender alli anta bandre male, female and others anta bartare. There also they have got the opportunity. Okay. But the reservation for them is very less. Only 1% or max 2% of the reservation will be there in government sector. Understood? Others also. Yes. They can also write the exam. They can also become IAS officer. They can also choose any of the legal profession. Business, trading, any of the profession. They can become doctor, they can become teacher, they can become anything which are legal. Okay. Section 377 ಇರಬೇಕು, that is related to that. Previously it was a criminal if publicizedly ಏನು ಅಂತಂದ್ರೆ these transgenders practicing the transgender, that was like a criminal previously. ಅದು ಕ್ರಿಮಿನಲ್ ಅಲ್ಲ ಅಂತ ಹೇಳಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡ್ತು, ಐ ಥಿಂಕ್ ಇನ್ 2007 or something, 2017. They can choose their life partners, either the gay or lesbians. But according to the Hindu Marriage Act, the marriage should be between only a man and woman. There is no law protecting for them to get married in India. There is no law that is restricting them for getting marriage in India for the transgenders. Okay, but that was decriminalized. The having the partner, the gays, the lesbians, these transgenders, they are protected for having their partners, for choosing their partner. But there is no tradition of marriage according to the Hindu Marriage Act for these transgenders. Understood? Next is Article 20. Very important. Protection in respect of conviction of offences. It is having 3 types here. First one, no ex post facto law. The second one, no double jeopardy. Second one is no jeopardy, no double jeopardy. The third one is no self-incrimination. These are very important. See, this Article 20 grants the rights for both citizen and also the foreigner. And what does this no ex post facto law means? Here, though no ex post facto law means for criminal activities, for crime, it is different. For civil cases, these are different. Let us study regarding the crime cases, the criminal cases. No ex post facto law. Okay, let me give one example for you. Think in 1990 there was a murder, okay, by one person. During that year, in that time, according to the IPC and CRPC, whatever the punishment, it might be till the maximum will be 14 years. Okay, he have committed a crime in the year 1990, but the judgment would have come in the year 2000. Still he will be in a prison. The trial, the hearings will be going on for 10 years. And during 2000, in that year, if the judgment comes, he is guilty, tappitasta, prove aitu andre, and if they give the punishment for 14 years, then from this year onwards, 14 years punishment sigalla. Already he has been took 10 years as a punishment there in trial and error. The trial hearing nalli he has been already there for 10 years in a prison. Now only for 4 years he will be there in a prison. Understood? And then in this year only, think that for a murder, that punishment was being decreased to only 7 years. See, now we are having Bharatiya Nyaya Samiti, okay, BNS, that all the acts are there from 2023 onwards. Okay, think that, okay, let me take this one as 2000. 2015, and this is 2023. In 2014, for a murder case, it is 14 years punishment, and in 2023, they have revived this punishment. They have may reduce this punishment for only for murder case. Now it is 7 years. Think for murder case, now it is 7 years, but before previously it was 14 years. Okay. The judgment, he has committed a crime in 2015, but the judgment came in 2023. Okay, in 2023. During that year only, BNS have been came into the force. And think that he has committed a crime in 2015 means he will get the punishment what was there in that year. ಅದು ಏನ್ ಜಾರಿಗೆ ಇತ್ತಲ್ವಾ ಅದು ಇರ್ತದೆ ಪನಿಷ್ಮೆಂಟ್ ಅವ್ರಿಗೆ. Even though the judgment in future would have been reduced there. But if I commit a crime when the BNS have been came into the force, I will get that punishment. Understood? That is what called as no ex post facto law. The punishment will not get changed accordingly. The punishment will be the same if you have done in that year, the same year. Punishment, the law will be applicable whatever the law has been there in that year. ಅದೇ ಯಾವ್ದು ಜಾರಿಯಲ್ಲಿ ಇರ್ತದನೋ ಅದೇ ಪನಿಷ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. That is what called as no ex post facto law. Ex post facto law means this will come into the force because judgment will be given in 2023. That's why whatever the recent punishment is there, that is into the force, that punishment will be given. But in India, we have chosen no ex post facto law. Means whatever the crime that has been took place in that particular year, that punishment will be in the force. That punishment will be given. That punishment will be imposed. Understood? Okay.
What if people know?
See, if he is innocent, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇನ್ನೋಸೆಂಟ್ ಅಂತ ಪ್ರೂವ್ ಮಾಡಿ ಮನೆಗೆ ಕಳಿಸ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೇ. ಓಕೆ, ವಾಟ್ ಎವರ್ ಹಿ ಹ್ಯಾಸ್ ವೆಂಟ್ ಥ್ರೂ ಫಾರ್ 10 years, ಅದಕ್ಕೇನೋ ಪರಿಹಾರ ಇಲ್ಲ. ಓಕೆ, ಸಮ್ಟೈಮ್ಸ್ ಏನು ಅಂತಂದ್ರೆ ಡಿಫೆಮೇಶನ್ ಮಾಡಿದ್ರು, ಓಕೆ, ನಾನು ಯಾರಿಗೋ ಡಿಫೆಮೇಶನ್ ಮಾಡಿದ್ದೀನಿ, ಅವ್ರಿಗೆ ಜೈಲ್ ಅನುಭವಿಸ್ತಾ ಇದ್ದಾರೆ. ಅಂಡ್ ಇನ್ ಫ್ಯೂಚರ್ ಇಫ್ ಹಿ ಇಸ್ ಇನ್ನೋಸೆಂಟ್, ಇಫ್ ಇಟ್ ಪ್ರೂವ್ಸ್ ಇನ್ನೋಸೆಂಟ್, I should pay some penalty for him. That's it. I should pay some penalty for the court. Court will give ಅವ್ರಿಗೆ ಏನು ಅಂತಂದ್ರೆ ಒಂದು ಪರಿಹಾರ ನಿಧಿ ಅಂತ ಕೊಡ್ಬೋದು ಅಷ್ಟೇ. ಓಕೆ, ಫಾರ್ ರೇಪ್ ಆಲ್ಸೋ, ಫಾರ್ ರೇಪ್ ಕೇಸಸ್, ಫಾರ್ ಮರ್ಡರ್ ಕೇಸಸ್, ಇದರ ವಿಕ್ಟಿಮ್ಗಳಿಗೆ ಪರಿಹಾರ ಅಂತ ಕೊಡ್ತಾರೆ. ಓಕೆ, but these are for criminal cases. But for civil cases like tax evasion, if you have done tax evasion in 2015 and the case, sorry, let me take this. Civil case in 2015, 2023, okay, 2025. Let me take 2022. Okay, if I have done my tax evasion in 2022, if the punishment is for, sorry, the penalty will be there. Okay, penalty with punishment will be there. If I done a tax evasion in 2023, so 22, then during that year, whatever the penalty is there, if it is 1 lakh, if it is 1 lakh and 3 years of punishment, 1 lakh along with 3 years of punishment, if the court gives a judgment that I am guilty and I have done my tax evasion in this year, then whatever the penalty and punishment is there in this year, I should pay this one. I may pay, the judge can impose that penalty and punishment of this year or else that one. Understood? Okay, but only for criminal cases, this is no ex post facto law. ಆ ವರ್ಷದಲ್ಲಿ ಏನ್ ತಪ್ಪು ಮಾಡಿರ್ತೀರೋ ಅದು ಯಾವ ಪನಿಷ್ಮೆಂಟ್ ಇರ್ತದನೋ ಅದೇ. But for civil cases, it is not like that. Okay, you might pay huge penalty or else lesser penalty. 50,000 ಆಗ್ಬೋದು ಇಲ್ಲಿ 10 ಲಕ್ಷನೂ ಆಗ್ಬೋದು ಇಲ್ಲಿ. It is 3 years there, it might be 7 years here also. You will get this punishment here. Tax evasion is the crime you have done intentionally. Understood? But the crime cases like murder, accident, that might be unintentionally also. But these are intentionally. You have intentionally evasion the taxes. That's why the punishment might be either of this year or else that year also. Have you understood this one? Next comes no double jeopardy. For same offense, no double punishment. For one offense, one punishment. If I murder one person, only one time punishment. Again and again, the court will not give the punishment for the same offense I have done. ಒಬ್ಬರನ್ನ ಕೊಲೆ ಮಾಡಿದ್ರೆ ಒಂದೇ ಪನಿಷ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೊಲೆ ಮಾಡಿ ಜೈಲ್ಗೆ ಹೋಗಿ ಆಮೇಲೆ ಏನೊಂದು ಬಿಡುಗಡೆ ಆಗಿ ಮತ್ತೆ ನಾನು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇನ್ನೊಬ್ಬರನ್ನ ಕೊಲೆ ಮಾಡಿದೆ ಅಂದ್ರೆ ಮತ್ತೆ ಪನಿಷ್ಮೆಂಟ್. ಅಂಡರ್ಸ್ಟುಡ್? No double jeopardy. No person to be prosecuted and punished for the same offense more than once. Understood? Next comes no self-incrimination. The person can't give the person can't be witness against himself. Let me explain this in detail. ತುಂಬಾ ಸತಿ ಆಗ್ತಾ ಇರುತ್ತೆ ಇದು. What is this no self-incrimination means? The accused person should not be a witness against himself. ಸ್ವಯಂ ಪ್ರೇರಿತರಾಗಿ ಬಂದು ನಾನೇ ತಪ್ಪು ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಬೇರೆ. ಇಲ್ಲಿ think that there is a person. There is a person and the police came to his home and they just arrested him based on the warrant. Okay, arrest warrant. Police will come to his home and they will issue the warrant. They will just show the warrant and they will just arrest that person. And he will be in a police custody. During police custody, okay, there will be a interrogation that will be done by whom? Police officers. During interrogation, okay, the interrogation should be a video interrogation or audio interrogation. The proof should be there. While you are interrogating that person, the police officer either he should do the video recording or else audio recording. Understood? And along with that, they can take his signature on some of the documents. Understood? While interrogation, while he is in custody. Think that there is one of the paper, okay, in that there is a lot of whatever the incident have been took place, they have already typed, it is typed by the police officers, and if they forcefully makes this person to give a signature, this will not be valid in front of court if he says in front of judge that this is invalid, this is not me, this is fake. They have forcefully made me to sign. Okay, whatever the person tells in front of the magistrate or a judge, that will be the final proof. This is not called a solid proof, because we don't know whether that police officers have beaten him till death and they have made him to do the signature. Understood? That's why, see how our constitution protects the people, whether he might be a victim or accused. These proofs, and also video recording, audio recording is also not a proof. It is not valid. Understood? video recording, audio recording that is made by the police officers while he is in custody, and also these kind of documents, whatever he signs, that will not be valid proof in front of the judge while he is in a trial or else in a hearing. Whatever he gives, the statement, if the person, if the accused or a victim, whatever they give that statement in front of judge, that is final. That is the final proof. Understood? Okay.
He cannot be written the accused also, witness also.
Yeah. ಸ್ವಯಂ ಪ್ರೇರಿತರಾಗಿ ನಾನು ತಪ್ಪು ಮಾಡಿದ್ದೀನಿ, ತಪ್ಪಿತಸ್ಥ ಅಂತಂದ್ರೆ ಇನ್ ಫ್ರಂಟ್ ಆಫ್ ಜಡ್ಜ್ ಪನಿಷ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. ನಾನು ತಪ್ಪೇ ಮಾಡಿಲ್ಲ ಅಂತ ಅಂದ್ರೂ ಕೂಡ, ಸಿ ವಿಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ನಲ್ಲಿ, ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ನಲ್ಲಿ ಫೋರ್ಸ್ಫುಲಿ ಆಗಿ ನಾನೇ ತಪ್ಪಿತಸ್ಥ ಅಂತ ಹೇಳ್ಸಿದ್ರೆ, ಬಟ್ ಇಫ್ ಹಿ ಸೇಸ್ ಇನ್ ಫ್ರಂಟ್ ಆಫ್ ದ ಜಡ್ಜ್ ದಟ್ ನಾನು ತಪ್ಪಿತಸ್ಥ ಅಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಗಿಲ್ಟಿ, ಐ ಆಮ್ ಇನ್ನೋಸೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ, that is the final proof. Understood? These are not the solid proof. The video recording, audio recording, and these kinds of documents, I mean signature documents of the accused or victim. The final, whatever they say in that hearing in front of judge, that is a final proof. Understood? ತುಂಬಾ ಕೇಸಸ್ ನಲ್ಲಿ ಆಗ್ತಾ ಇರುತ್ತೆ ಇದೆಲ್ಲ. See, these are for normal cases, but for terrorist, when it comes to the terrorism, these proofs are valid. Video recording, audio recording, and this kind of signature, that are valid. Exceptionally that for murder case, rape case, theft, robbery, accident, ಇದಕ್ಕೆಲ್ಲ solid proof ಆಗಲ್ಲ. Audio recording, video recording, and these kinds of statements, written statements. But when it comes to terrorism, if NIA team, that is National Investigation Agency, if they have arrested this person, this accused persons, whatever the statement he gives in front of the NIA team, and also the video recording, audio recording, whatever they do while he is in custody, that is a solid proof. Because terrorism is very extreme in nature, very sensitive ಅದು. ಓಕೆ, ಅಲ್ಲಿ ಏನು ಅಂದ್ರೆ police are having, the NIA team are having more rights over there. Understood? Have you understood how to discriminate these kinds of cases? Okay. Protection against self-incrimination extends to both oral evidence and written evidence. Oral evidence means video recording, audio recording, ಬಾಯಿಂದ ಹೇಳ್ಸೋದು, and written documents. Okay. And also, however, it does not extend to compulsory production of material objects and compulsion to give thumb impression, specimen signature, blood simmons. See, if he is a victim or culprit or accused, he should compulsory give blood test and specimen test, DNA test. For DNA, if there is a requirement of blood or hair follicles or even the sperm, that all should be given by this person. ಅಲ್ಲಿ ಡಿನೈ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ನಾನು ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಓಕೆ, ಈ ತರ ಇದೆ. ಕ್ರಾಸ್ ಎಕ್ಸಿಬಿಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ದೇ ನೀಡ್ ಆಲ್ ದಿಸ್ ಕೈಂಡ್ಸ್ ಆಫ್ ಪ್ರೂಫ್ಸ್. And also thumb impression. Okay, the fingerprint. If there is a need of for the police officers, he should give that. Have you understood this one? Article 20. No ex post facto law. No person shall be convicted to any offense except for violation of law in force at the time. See here. Violation of law in force at the time of commission of act. Means whatever the offense he makes while the law is in force. If the law says that punishment is for 14 years, ಆ offense ನ ಮಾಡಿದ್ದ ಅಂತಂದ್ರೆ ಅದೇ punishment ಅವನಿಗೆ ಅಂತ ಹೇಳಿ. Next, subjected to penalty greater than that prescribed by the law in force at the time of commission of the act. This second one is for the civil cases. This is for criminal cases, this is for civil cases. Civil cases ಏನ್ ಹೇಳ್ತದ? Penalty greater than that prescribed by the law. in force at the time of commission. ಇನ್ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರುತ್ತೆ ಅಲ್ಲ, ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಪೆನಾಲ್ಟಿ ಜಾಸ್ತಿ ಇತ್ತು ಅಂದ್ರೆ ಅದೇ ಪೆನಾಲ್ಟಿ ಕಟ್ಟಬೇಕು. ಪನಿಷ್ಮೆಂಟ್ ಆಲ್ಸೋ ದ ಸೇಮ್ ಒನ್. ಅಂಡರ್ಸ್ಟುಡ್. ಬಟ್ ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ಅಂತ ಬಂದಾಗ, when I commit a crime in 2025, whatever the punishment is there for murder, I will get that only in future. In 2035, ಇನ್ನೊಂದು 10 ವರ್ಷ ಆದ್ಮೇಲೆ ನನಗೆ ಏನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರು ಅಂತಂದ್ರೆ, ನಾನು ತಪ್ಪಿತಸ್ಥ ಅಂತೇಳಿ, ನನ್ಗೇನು ಅಂತಂದ್ರೆ, ನಾನು ಇವತ್ತೇನ್ ಕ್ರೈಮ್ ಮಾಡಿರ್ತೀನಲ್ಲ, ಯಾವ್ದು ಪನಿಷ್ಮೆಂಟ್ ಇರ್ತದೆ ಅಲ್ವಾ, ಅದು ಅವಾಗ ಕೊಡ್ತಾರೆ. ಇಫ್ ಐ ಆಮ್ ಗಿಲ್ಟಿ, ಇಫ್ ಐ ಆಮ್ ನಾಟ್ ಇನ್ನೋಸೆಂಟ್. 10 ವರ್ಷ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅವಾಗ ಮತ್ತೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತ ಅದು ಬೇರೆ ಲೈಟರ್ ಪನಿಷ್ಮೆಂಟ್ ಇತ್ತು ಅಂದ್ರೆ ಅದನ್ನ ಕೊಡೋದಿಲ್ಲ ನನಗೆ. ಅಂಡರ್ಸ್ಟುಡ್. Is there any doubt? Shall we go for Article 21? You can write the examples of your own now. Illandre you will be forgetting that. Write down for civil cases, for firstly for criminal case, for civil case, then this double jeopardy and no self-incrimination. Write down in your own words whatever you know. Write down other example for this. No ex post facto law. Other example in 2020 and 2025. In 2020, if any of the person has done a meme of the politician, if any of the person has done, if any person has done a meme against politics, no punishment during 2020. There was no punishment. Actually, there was no punishment for doing the memes against politicians. But in 2025, according to Bharatiya Nyaya Samiti, there is a punishment of 2 years. If you do a meme against any politician now, you will be jailed for 2 years. But if the judgment comes in 2026 that you have done the offense in 2020, 2020 ನಲ್ಲಿ offense ಮಾಡಿದೀರಾ, but judgment 2026 ನಲ್ಲಿ ಬಂದಿದೆ ಅಂದ್ರೆ no punishment. Why? Because you have done a crime. Sorry, you have done crime in 2020. During that time, the law says that there is no punishment. But if you have done a crime in this year, from 2025 onwards, then there is a punishment of 2 years. These offenses are not retrospective in nature. Retrospective ಅಂತಂದ್ರೆ ಚೇಂಜಸ್ ಆಗೋದಿಲ್ಲ. ಇವತ್ತೇನ್ ಜಾರಿಗಿರ್ತದೋ ಅದು ಆಗೋದಿಲ್ಲ. ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್. Okay. These are not retrospective in nature. Retrospective ಅಂದ್ರೆ ಆ ಇಯರ್ ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಅದೇ. But see, this is a criminal. Civil will be retrospective in nature. Civil cases will be retrospective in nature. Retrospective punishment. Okay. Civil cases will have retrospective punishment. Civil cases will have retrospective punishment. Understood? Let us go for Article 21. Protection of life and personal liberty. Very, very important for your exam. It is for both citizens and non-citizens of India. This is one of the wider article. Wider and important article. This article is for both citizens and non-citizens. Okay, let us see what is Article 21. Article 21 says that protection of life and personal liberty. Firstly, in original article, in original constitution, they have added the protection of life. Then they added the personal liberty eventually. Then right to privacy. In original constitution, what they have added? Only protection of life. Then eventually they have added personal liberty in Menka Gandhi case. And eventually right to privacy in 2017. Okay, let us see that. Okay. What are the categories that comes under right to privacy? Sorry, right to life and personal liberty. Meant by that. Right to life means ಜೀವಿಸುವ ಹಕ್ಕಿದೆ. Every human beings, whether you are citizen or non-citizen, it doesn't matter. If you are citizen or non-citizen, it doesn't matter. Everybody are having that right to live on this earth. That is what called as Article 21. Right to livelihood. Okay. And also right to sleep is a article, fundamental right. Right to sleep ಅಂತ ಹೇಳಿ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಮಲ್ಕೊಂಡ್ರೆ ಆಮೇಲೆ ನನಗೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಹೇಳೋದಲ್ಲ. ಓಕೆ. Right to sleep in the sense that during night time you can sleep. Okay. Nobody can disturb the people. And also a sound pollution ಅಂತ ಬರ್ತದೆ. There also there is a restriction of till 10 to 6 there should be a lesser sound pollution, that too in the decibels ಇರ್ತದೆ. In peaceful, in residential areas it is less than 45 decibels ಅಂತ ಅನ್ಸುತ್ತೆ. In industrial area it is less than 55 decibels ಈ ತರ ಇರ್ತದೆ. Okay. And right to sleep ಆಗಿರ್ಬೋದು, right to have electricity for your home. Okay. The KPTCL, BESCOM, GESCOM, these kinds of the various government bodies, they can't restrict you by offering the electricity. They should provide you the electricity. Understood? There are a lot more things. Let us see that. Let me just tell you. Right to live with human dignity. Right to decent environment, including pollution-free water, air, and also protection against hazardous industries. Right to livelihood, right to privacy, right to shelter, right to health. You are having that right. Right to health. Next, Right to free education up to 14 years of age. Right to free legal aid. What is meant by right to free legal aid? Yeah, see here. If any of the person who is into a weaker section, for them, if there is a necessity of having the lawyers for running the case, the free legal services should be given from the government. They should appoint the lawyer for you. Yeah, public prosecutor. Okay. Next one, right against solitary confinement, a right to speedy trial, a right against handcuffing, a right against inhuman treatment, right to travel abroad. You are having the right to travel abroad. But if you are having case against you during that time, you have been restricted to go for the abroad. Okay. During normal, if you don't even have any of the single case against you, you can travel for abroad. Right against bonded labor, jeetdalu. Okay. And right against custodial harassment. In movies, they will show that the police officers will give the third degree treatment. Okay. That kind of custodial harassment will not be there, should not be given. Next, right to medical emergency aid. Think that if there is any accident happen took place on the road, okay, we should take that person and we should give him, we should make him to let them give at least a medical first aid treatment in a hospital, any of the hospital. Okay, at least badukso can be first aid treatment that should be provided by all the hospital, whether it's a private hospital or government hospital, it doesn't matter. Okay, and next, right to timely medical treatment in government hospital. Next, right of prisoner to have necessities of life. These prisoners, for prisoners, at least the basic facilities should be given there. The food facility, the shelter. Okay. Next, right against public hanging. Okay. In public, see, ಹಳೆ ಕಾಲದಲ್ಲಿ ಏನಿತ್ತು ಪಬ್ಲಿಕ್ ಹ್ಯಾಂಗಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ರು ರಾಜ್ಯ ಮನೆತನಗಳಲ್ಲಿ ಟೈಮ್ ನಲ್ಲೆಲ್ಲ. But according to constitution, there should not be any public hanging. Okay, nobody can give the punishment called as public hanging. Understood? And right to information, RTI, that is also in Article 21. Next, right against bar fetters. Right against bar fetters. What is that? Right against bar fetters. Don't know. See, for a culprit for or else for accused crime, these police officers, they will put that bar fetters. ಅದು ರೌಂಡ್ ಆಗಿರ್ತದೆ ನೋಡಿ. ಸಿ ದಿಸ್ ಇಸ್ ಎ ಪರ್ಸನ್ ಕೊಳ್ಳಲ್ಲಿ ಒಂದು ಸ್ಟೀಲ್ದು, ಕೈಯಲ್ಲೆಲ್ಲ ಕಾಲಲ್ಲೆಲ್ಲ ಕಿಚ್ಚೋರ್ ಹುಚ್ಚ ಮೂವಿ ಇದೆ ನೋಡಿ ಸುದೀಪ್ದು. Okay, that kind, police officers can't give that kind of treatment. Okay, that is right against bar fetters. Okay. And right to sleep, right to opportunity, right to freedom from noise pollution. That all the privileges will be given for the people under Article 21. Understood? Next, right to personal liberty. Okay, let us see this. Okay. There is two cases in this right to life and personal liberty. First one is Gopalan case. Gopalan case of 1950. Gopalan case of 1950. Gopalan case of 1950. In this case, the Supreme Court has given the judgment that this Article 21 is against, if the law is violative in nature, you can take action against only the arbitrary executive actions, only for the arbitrary executive actions. Who are the executive actions here? Executives means bureaucrats, the civil servants. But you can't take the action against the legislatures. Concentrate here. Who will create the laws? Legislatures. If they create the laws, for them, there is no action against these legislatures. While they are implementing these laws, so-called the executives, for them, there is a punishment. Understood? See, this Article 21 regarding the life, while they are implementing this law, that is protection of life and liberty, personal liberty, for this, whatever the laws this legislature creates, okay, for them, there is no arbitrary action for these legislatures. Or ಮೇಲೆ ಏನು actions ತಗೊಳ್ಳಿಕ್ಕೆ ಆಗೋದೇ ಇಲ್ಲ. But only for the executives, they can take the actions. ಅಂದ್ರೆ ಇವ್ರು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅಂತ ಅರ್ಥ ಅದು. Okay, when it comes to the protection of life and personal liberty. But in America, in USA, there is, see, ನಮ್ದೇನಿದು, this concept have been created with the help of procedure established by the law. These laws will be created by whom? Legislatures. ಅಂದ್ರೆ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ ಮಾಡ್ಬೋದು ಅಂತ ಅರ್ಥ ಕೊಡುತ್ತೆ. But when it comes to the USA Constitution, they use the due process of law. Very important, frequently asked question in our prelims. According to the due process of law, it says that for the protection of life and personal liberty, whatever the laws these legislatures create, if it is against the Constitution, if it is violating your life, then that law will be declared as null and void. Here, in first time, in Gopalan case, it was a narrower law. It was narrower in action. But in Menka Gandhi case, this Supreme Court overruled this Gopalan case. That whatever the law that is created by the legislatures should protect the life of people. Should protect the life of people along with the personal liberty, their freedom also. It should not violate this one. Whatever these legislatures create the laws, if it violates this one, that will be declared as null and void. Understood? Okay. There was a time of election. During that time, okay, Menka Gandhi, she is now the aunt of the Rahul Gandhi, okay, Sanjeev Gandhi ಹೆಂಡತಿ ಅವರು Menka Gandhi, and she wanted to travel for abroad. But during that time, the government of India, during that time, they infringed the rights of the Menka Gandhi, that is a personal liberty. What happened is, the airport authorities, they took away her passport. She challenged in a court that my personal liberty was being infringed by the airport authorities. Airport authorities have took her passport and submitted for government of India. When there is a violation of fundamental rights of Article 21, she approached Supreme Court. Supreme Court told that these lawmakers should not violate the protection of life and also personal liberty, her freedom. If there is any criminal case against her, like murder case or rape case or accident case, during that time, the airport authorities can take away her passport. But when there is no criminal cases against that person, how they can infringe her rights? Then this due process was being implemented in India also by the Supreme Court. Supreme Court held to. Let us take the concept of USA, that is due process of law. Let us protect the people of India. These lawmakers will create the laws that will violate the life and also the personal liberty. Understood? That's why with the help of due process of law, it says that these legislatures, whatever they create the laws, that should be fair and just. Just ಅಂದ್ರೆ justice. ನ್ಯಾಯಯುತವಾಗಿರಬೇಕು. Whatever the laws they create, they should be fair and just. If they are fair and just, then these laws will be implemented by these executives. If the laws are unfair and unjust, then these will be declared as null and void. Understood? Till Menka Gandhi case, that Menka Gandhi case in 1978, Gopalan case, in Gopalan case, what they told? The Supreme Court told that legislatures are having more power, let them create the laws. We can't interfere in that. But in 1978, it overruled the Gopalan case. Ulta kortu judgment. What was it? Yeah, it can take the action against these also. Okay, and it can declare null and void if the legislatures create the law that are unfair or unjust antali. Understood? Write down. Let me dictate. In the famous Gopalan case of 1950, the Supreme Court has taken the narrow interpretation of Article 21. Full stop. The protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative actions. Full stop. This means that a state can deprive the right of life, deprive the rights of life and personal liberty of a person. Full stop. This is because of procedure established by the law. Full stop. Next paragraph. In Menka Gandhi case, In Menka Gandhi case. In Menka Gandhi case, 1978, the Supreme Court overruled its judgment. That with the help of due process of law, apostrophe of American expression, Article 21 should be available not only against arbitrary executive action, but also against arbitrary legislative actions. Full stop. The laws should be reasonable, comma, fair and just. Full stop. Have you understood this concept? In Gopalan case, what the Supreme Court has given the judgment? They will take action against only arbitrary executive action, okay, and not against legislative actions, arbitrary legislative actions. But it overruled its judgment. Ulta judgment kortu. Yelli. Menka Gandhi case of 1978. Firstly, it was a procedure established by the law. Yavadu Gopalan case. Due process of law, that concept was derived from America and it was being used in which? Menka Gandhi case. Understood? Due process of law should be what? It should be reasonable, fair and just. Due process of law should be reasonable, fair and just. Menka Gandhi case alli due process of law use madidare. Understood? Just try to read the M. Lakshmikant daily. Okay. Next comes Article 21. Okay. Article 21. That is protection of life and personal. Article 21A. Article 21A. Article 21A. Right to education. Here, the free and compulsory education should be given by the states for the needy people. ಯಾರು ಬೇಕಾದ್ರೂ ಗೌರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ಸಿಗೆ ಹೋಗ್ಬೋದು. Okay, that is what they say here. The state shall provide free and compulsory education for whom? For the children between the age of 6 to 14. Free education, compulsory education kodbeku. If the parents are willing to send them for private school, let them send. But what is the duty of the central government, state government here? They will establish government schools. Let them take the education there between the age of 6 to 14. And also, this is not compulsory. This law is not compulsory for the high school students. That is elementary school students. After the age of 14, it is not compulsory for the citizen of India to go for the elementary schools. If they wish to go for the school, let them go. We will be providing primary government school, elementary government schools, colleges, government degree colleges. But if they wish to go, let them go. It is based on their desires. And this provision, Article 21A, as it is A, it is amended and has been added as a clause. Okay? And when it was been amended, 2002, with the help of 86 Constitutional Amendment Act in 2002, they have added right to education. What is the aim of this? Education for all. Education for all is the aim of the right to education. See, this right to education is the only one concept that has been added in fundamental rights as Article 21A, DPSP as Article 45, and also in fundamental duties in the last one. ಮೂರರಲ್ಲೇನೋ ನೋಡಿ, fundamental rights, DPSP, fundamental duty. Only this single concept have been added in all these three subjects: fundamental rights, DPSP, and fundamental duty. Understood? Next is Article 22. We explain this will be the class. Article 22. Next 23 in the 35. In next session I will complete that. Okay. Next session alli fundamental rights ಮುಗಿಯುತ್ತೆ. ಅದಾದ್ಮೇಲೆ DPSP and fundamental duty in one day. Article 22, that is protection against arrest and detention. One of the important one, as like Article 20. See, there are two types of detention here. Arrest. Detention means arresting. There are two types of arrest. One is punitive, another one is preventive. Punitive. What is meant by punitive detention? Yes, is to punish a person for an offense committed by him after trial and conviction in a court. Means arresting a person after committing a crime. Think there is a person, he has committed a murder, and this person, accused person, will be arrested once he has done his crime. Okay, after doing his crime, ಗೊತ್ತಾಗ್ತದೆ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಏನು ಅಂತೇಳಿ, then he will be arrested, and based on trial and here they will give the punishment. Next comes the preventive detention. Here preventive detention means arresting a person before doing the crime, especially the terrorist. Understood? Think that one of the unknown person will call and tell for the police officer that this person wanted to bomb blast in this area, and I am having the solid proof of that. And once these police officers get to know that matter, then they will arrest the person before committing the blast crime. Understood? In other hand, it means that detention, arrest of a person without issuing the warrant. Here the warrant should be issued, but in preventive detention warrant is not compulsory there. Okay, a warrant anna, see, in that warrant we should take the permission of higher authorities, signature alli irbeku, ಅಷ್ಟಾಗೋಷ್ಟರಲ್ಲಿ bomb blast ಆಗಿ ಹೋಗಿರುತ್ತೆ. That is why in our constitution they have not added the warrant for this preventive detention. Warrant is not required here. Here the warrant is required. Understood? Is there any doubt? And also along with that, if there is any, see, for this one, punitive detention, this is the ordinary law. Punitive detention is the ordinary law. Here, if that accused, firstly, for that person, ಏನು ಅಂತಂದ್ರೆ they should inform, the police officers should inform on what grounds they have arrested him. Think that I'm in a home, okay, and they will knock the door, police officer will knock the door, and they should inform me on what grounds they are arresting me. Okay, ಏ ಬಾರಯ್ಯ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕರ್ಕೊಂಡು ಹೋಗೋದಲ್ಲ ಯಾವುದೇ ಆಗಿರ್ಲಿ. Without knowing the matter why they are arresting me, okay, see, I am having rights according to the Article 22. I can know on what grounds they are arresting me. They should intimate on what grounds they are arresting me, and once they arrest me, then what it will happen? They should consult my family as well. They should tell for what reason we have arrested. And once they just intimate for the friends or else relatives, then I am having the right to choose the lawyer for me in order to defend myself. Okay, and I can just ask them the permission that I need a lawyer for me, and then they will just make me to just have the interaction with the lawyer as well. And then within 24 hours, that person should be submitted in front of the district magistrate, excluding the traveling hours. Okay, within 24 hours of arresting, okay, they should submit that person in front of the district magistrate. And then if the district magistrate agrees for this person to be in custody, see, maximum the police custody is for 14 days. Okay, and sometimes based on the conspiracy, based on how what is that case, a case yaudide ಎಷ್ಟು strong ide, based on that police should prove that we wanted this many of the days for a custody. Okay, and district magistrate will sanction that custody dates like 7 days or 10 days or 11 days or only 2 days also. Okay, based on what kind of crime it has been. Okay. And then for a lady accused, there should be a lady police officer should be arresting her. Okay, not the gents police officer is not having the right to arrest the lady accused. And in the presence of lady sub inspector or else any lady police officer, they can arrest. And along with that, if any of the lady accused, if the police officer wanted to arrest the lady accused at the night time, the lady should be there compulsory, even it's a daytime or at night time. But during night time, okay, if police officers come to the home and they are arresting the lady accused, when they are submitting her in front of the district magistrate might question the police officers, why you have arrested her only at the night time, why not during the daytime? It is the police officer should give the valid reason why they have arrested her at the night time. If she wanted to abscond during night, if it is a valid proof that she wanted to abscond, then they can arrest her at the night time. ಹೋಗಿರ್ತಾರೆ ಮನೇಲಿ ಮಲ್ಕೊಂಡಿರ್ತಾರೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ, ಹೌದಾ, ಪೊಲೀಸರು ಬಂದು ಬಾಗ್ಲ ಬಡ್ದು ಸುಮ್ನೆ ಕರ್ಕೊಂಡು ಹೋಗೋದು, ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು, ದಟ್ ಈಸ್ ನಾಟ್ ದ ಕೇಸ್ ಹಿಯರ್. ಓಕೆ, ಅವಳು ಏನಾದ್ರೂ ಅಬ್ಸ್ಕಾಂಡ್ ಆಗ್ತಾ ಇದ್ಲಂದ್ರೆ ಮಾತ್ರ ಪೊಲೀಸ್ ಕ್ಯಾನ್ ಅರೆಸ್ಟ್ ಹರ್ ಡ್ಯೂರಿಂಗ್ ನೈಟ್ ಟೈಮ್. Okay, see, these are the various procedures. Is there any doubt? And ladies ಗೆ ಪ್ರಿಸನ್ ಬೇರೆ ಇರ್ತದೆ, ಜೆಂಟ್ಸ್ ಗೆ ಪ್ರಿಸನ್ ಬೇರೆ ಇರ್ತದೆ, ಒಂದೇ ಕಡೆ ಇರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. Okay. And also if she is having the baby, if that lady accused is having the baby, ಆ ಬೇಬಿನ ದರ ಹೇಳ್ಕೊಂಡು ಕರ್ಕೊಂಡು ಹೋಗೋದಲ್ಲ police ಸ್ಟೇಷನ್ಗೆ. Some of the people will do like that. Some of the police officers. That baby, they should know the age of that baby, and ಅದು 1 year ಲೆಸ್ ಇದೆನಾ ಅಥವಾ ಇಟ್ ಈಸ್ 3 years or 4 years ಇದೆನಾ, ಅಂಡ್ ಆ ಮಗುನ ಅಲ್ಲೇ ಮನೆಯಲ್ಲೇ ಯಾರಿಗಾದ್ರೂ ರಿಲೇಟಿವ್ಸ್ ಒಪ್ಪಿಸ್ಬೇಕು ಅಥವಾ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಒಪ್ಪಿಸ್ಬೇಕು ವೆನ್ ದೇ ವಾಂಟೆಡ್ ಟು ಅರೆಸ್ಟ್ ಹರ್. ಓಕೆ, ಇಲ್ಲ ಅದು ಇನ್ನೂ ಹಾಲು ಕುಡಿಯೋ ಮಗು ಇದೆ ಅಂತಂದ್ರೆ ಸಿ ದ ಟ್ರೀಟ್ಮೆಂಟ್ ಶುಡ್ ಬಿ ಗಿವನ್ ವೆರಿ ಡಿಫ್ರೆಂಟ್ಲಿ ಫಾರ್ ಹರ್. ಓಕೆ, ಸಿನ್ಸ್ ಇಟ್ಸ್ ದ ಬೇಬಿ ಈಸ್ ಫೀಡಿಂಗ್ ಬೇಬಿ ಇರೋದ್ರಿಂದ ಏನು ಅಂತಂದ್ರೆ ಸಿ ದಟ್ ಆಲ್ ದಟ್ ಮ್ಯಾಟರ್ಸ್ ಡ್ಯೂರಿಂಗ್ ನೈಟ್ ಟೈಮ್ they can't suddenly come to the home and they can't arrest her. Okay, and that all that will be just seen during that time by the district magistrate. Okay, have you understood all this? See, but in prevention detention, once they arrest, there should be solid evidence to prove that person is guilty. If the trial and hearing goes beyond 3 months, okay, again the advisory board panel will be there. Okay, they should justify, and I mean they should get the justification from these police officers that this person has committed the crime. Okay, sitting in a punitive, especially in a preventive detention, the terrorists and also the serial killers, okay, those people will get arrested here. Only the time given for the police officers is to prove within 3 months that this person is guilty. Okay, or if that panel, see, there will be judges in that panel, if they feel that sufficient solid proofs are against him, okay, again it can be extended, the trial can be extended, and he will not get any bail. See, in taking the bail in this preventive detention is very difficult, but in this they can take the anticipatory bail, or else there are 3 types of bails. Regular bail sigutte, illi it is very difficult in preventive detention. Is there any doubts? Okay, let us wind up the class there. Which is the 12th article, that deals with what? 13th article, definition of law. 14th article, equal protection of law. Sorry, equality before law and equal protection of law. Next one, article 15. Yeah, no, prohibition of discrimination based on these grounds: race, religion, caste, sex, place of birth. Next one, article 16, for employment, public employment. Okay, then 17, abolition of untouchability. 18, abolition of titles. 19, right to freedom. It is having 6 rights. First one, right to freedom of speech and expression. Next one, right to assemble, right to association. See, how to remember that one? First ಏನು ಅಂತಂದ್ರೆ freedom of speech and expression. I'm having freedom of speech and expression. When I'm doing speech, people will assemble. Okay, ಈ ತರ tricks, mnemonics ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋಣ. When I'm doing the speech, people will assemble. That is second one, assemble. Then what I will do? I will do the association, ಸಂಘಟನೆ ಕಟ್ಬಿಡೋದು, or union. Okay, then what I will do? I will do the movement with these people in mass gathering. Okay, ಈ ತರ. Then finally, reside in one place for temporary basis. Lastly, the profession. Okay, next one, article 20. Yes, that is having 3 types: no ex post facto law, no double jeopardy, no self incrimination. Next, article 21, right to life and personal liberty. Article 21A, right to education. Article 22, protection against arrest and detention. Understood? Is there any doubts? No. Let us wind up the class. Okay.